Okay, Attorney Claire Portis.
Yes, good morning, Your Honor. I have two cases on the docket, number 1 and number 41.
Okay, number 1, CL 161629-I, Portfolio Recovery versus Marcos Sanchez. And what is your announcement?
Yes, Your Honor, it's set for trial, but we still have not been able to notice defendant on it. So I asked for a short continuance to make another attempt.
Okay, how soon? I have September 15th or September 29th, or then we'll go into October.
About September 29th.
Okay, that'll be September 29th at 9:30 a.m.
Thank you, Your Honor.
Okay, and you also had number 41?
Yes.
Okay, CL 210230-I, Velocity Investments et al. Versus Jorge Peña and Carla Peña. And what is your announcement?
This one, we're asking for this matter to be set for trial. We're here for a status conference today, and at the last setting, I believe we were set for on motion for default judgment, and the defendant appeared. We were provided their number, and we also provided our number. We have not heard from them, so that's go ahead and get a trial setting.
Okay, let me see. Jorge Peña or Carla Peña, are you present?
Yes, I'm here.
Okay, Ms. Peña, you heard well, you're representing yourself, is that correct?
That is correct, yes.
Will you be continuing to represent yourself?
Yes.
Okay, then opposing counsel has made an announcement that they have not had any contact with you, even though they provided you with the contact information. Are you? Do you want to have an opportunity to speak to them, or do you want me just to set this for trial?
No, we spoke right now to Robert, who was the attorney that we had the meeting with the first time. But if I could get, a little bit of more time, my husband's at work right now, so it's very hard for me to go back and forth with him right now. If I could just get a little bit more time just to go over, we were going over some options for payment.
Okay, I'm going to give you an opportunity to do that. I'm going to reset your status for September the 29th at 9:30 and try to contact them in plenty of time prior to that hearing, okay?
Okay, sounds great. Thank you.
Okay, Ms. Portis, I'm going to give you one more opportunity for them to have a chance to speak with you all.
Thank you, Your Honor.
Thank you.
Okay, anything else?
That's all I have. May I be excused?
Yes, you both may be excused.
Thank you.
Okay, Attorney Rogelio Garza.
Good morning, Your Honor. Number
Good
6
morning.
on the court's docket, we're set for a friendly suit hearing.
Okay,
And I
that is CL 194471-I, Barbara Daniela Soltero Chavez et al. Versus Eric Alexander Garza. Are all the parties present?
Yes, Your Honor. Rogelio Garza on behalf of the plaintiff.
Alex Good on behalf of Mr. Garza. Your Honor, my apologies. My camera is apparently not working. I'm suited up and ready, but I would be late if I had to restart my system.
Okay, I'll take your word for it.
Okay.
Your Honor, good morning. Ana Cedillo is the advisor appointed by this honorable court.
Okay, and Mr. Garza, who do you need sworn in?
Barbara Soltero. I know she is on video. It's under Barbara.
Okay, Ms. Soltero, can you hear me?
And we could say, we could have an interpreter, Your Honor.
Okay.
Speak
Ms.
Spanish.
Castaneda, can you please ask Ms. Soltero if she can hear us?
Barbara Soltero, ¿nos escucha?
She probably has a microphone on mute, Your Honor.
I see her raising her hand, Your Honor.
Aquí estoy. Sí.
Okay, all right. Okay, please ask her to raise her right hand.
Ms. Soltero, por favor, levante su mano derecha.
Do you swear that the testimony that you are about to give is the truth, the whole truth, nothing but the truth, so help you God?
Jura que el testimonio que está a punto de dar es la verdad, toda la verdad y nada más que la verdad.
Sí.
Yes.
Okay, you may proceed, sir.
Thank you, Your Honor. Please state your name for the record.
Por favor, diga su nombre completo.
Bárbara Daniela Soltero Chávez.
Bárbara Daniela Soltero Chávez.
You are the mother of Alfonso Miguel Hernández Soltero.
¿Usted es la mamá de Alfonso Miguel Soltero?
Sí.
Yes.
And he is a 3-year-old son that was involved in an auto accident?
y es el niño de 3 años que fue involucrado en un accidente.
Sí,
Yes.
You understand we're here today asking the judge to approve an offer that had been made by the defendant?
¿Y está usted de acuerdo que estamos aquí para que la juez apruebe un compromiso que llegamos con el defendiente?
sí,
Yes.
Now, your son was taken by the ambulance to the hospital. He got checked and there were no reported injuries. Is that correct?
Su hijo se lo llevaron por ambulancia y lo checaron y no había lesiones, ¿correcto?
sí.
Yes.
And ever since then, he has reported no injuries. And is he doing well today?
Y desde entonces no ha reportado ninguna lecciones. ¿Y está el niño bien hoy?
Sí,
Yes.
You understand that the offer is for $5,000 and $1,265.08 are left for the benefit of the child?
Usted entiende que el caso es por $5,000 y le quedaron $1,265.08.
sí,
Yes.
You also understand that normally that money goes into the registry of the court, but today we're asking the judge to allow you to keep that money.
Y regularmente ese dinero se pone en el registro de la corte, pero estamos aquí pidiendo que se lo entreguen a usted.
sí,
Yes.
Alfonso is 3 years old, is that correct?
Y Alfonso tiene 3 años, ¿correcto?
sí,
Yes.
And unfortunately, he suffers from spina bifida, so he requires extra care in which you have to take him back and forth to therapies.
Y el niño tiene una lesión de la espina bífida que tiene que llevarlo usted a terapias.
sí,
Yes.
And that would greatly help you in your transportation costs. Is that
Y
correct?
eso le ayudaría a usted en la transportación.
sí,
Yes.
Alfonso is only 3 years old. Is that correct?
Alfonso tiene 3 años, ¿correcto?
sí,
Yes.
Do you understand would be a final judgment?
Y usted entiende que este sería un juicio final.
sí,
Yes.
Do you feel it's in the best interest of your son to accept the offer?
Y usted siente que esta oferta es en el mejor, es lo mejor para su hijo.
sí,
Yes.
Are you asking the court to approve the settlement offer?
Y está usted pidiéndole a la corte que acepte esta oferta de acuerdo.
sí,
Yes.
And are you happy with my services as well as those of Ms. Edna Cedillo?
Y está usted contenta con mis servicios y también los de la señorita Edna Cedillo.
sí.
Yes.
I'll pass the witness, Your Honor.
Okay, Mr. Good?
I believe, well, I've got 2 questions. Ms. Soltero, do you understand that if we were to take this matter to a jury that they could award you more or less for your child?
Mesotero, ¿y usted entiende que si esto fuera un jurado, podrían darle más o menos en el jurado?
Sí,
Yes.
But you're waiving the jury trial because you believe that this is in the best interest of Alfonso?
Pero usted está renunciando al jurado porque cree que esto es en el mejor interés para Alfonso.
sí,
Yes.
I appreciate your time, Ms. Soltero. I have no further questions. I'll pass the witness.
Okay, Ms. Cedillo?
Yes. Good morning, Ms. Soltero. Do you recall visiting with me at my office along with your son?
Mesotero, ¿usted recuerda haberme venido a visitar a mi oficina con su hijo?
sí,
Yes.
And we had an opportunity to discuss how your child was doing and any injuries that may have occurred as a result of this accident. Is that correct?
Y usted recuerda que tuvimos una plática de cómo estaba su hijo y cualquier lesiones que tenía su hijo?
sí,
Yes.
Okay. And do you understand the amount of the settlement offer? Has that been explained to you?
Y usted entiende la cantidad de la oferta que le están, la oferta de liquidación que le están dando.
sí,
Yes.
And you've had an opportunity to ask questions with regards to that?
Y usted tuvo una oportunidad de hacer preguntas tocante eso.
sí,
Yes.
And you do believe that that's in the best interest of your child, correct?
Y usted sabe que usted piensa que ese es para el mejor interés de su hijo.
sí,
Yes.
And when we spoke, you were eager to close out this case, is that correct?
Y cuando hablamos, usted ya quería cerrar este caso, ¿correcto?
sí,
Yes.
You understand that once this is finalized, you cannot come back to seek any damages for any additional injuries or any other claims, is that correct?
Y sí entiende que ya cuando finaliza no puede venir para atrás para recurrir más dinero, ¿correcto?
sí.
Yes.
I have no further questions, Judge.
I have nothing
Okay.
further.
Okay, Ms. Dio, you are in agreement for the remaining amount of $1,265.08 be given directly to Ms. Soltero instead of the registry of the court?
Yes, Your Honor, normally that wouldn't be something that I would think would be in the best interest. However, knowing the needs of the child, I was able to visit with mom and the child. I saw how she struggles and the needs of this child. And so I don't have any issues with that being given directly to the child, Judge, or to mom.
Okay. Okay, then the court will accept the agreement as testified to onto the record. Has this already been set forth in an agreed settlement order?
Your Honor, I wasn't sure how the court was going to rule on that issue. I've got it drafted and we can submit it now that we understand the court's ruling.
Okay, just make sure that all parties sign off on it, please.
Understood.
Thank you, Your Honor.
Okay, I'm gonna set a tickler for that to be submitted to the court by August the 27th.
Yeah, I'll submit it today, Your Honor. It's ready to go.
Okay,
Thank you, Your Honor.
okay. All right,
May
thank
we-
you.
Okay.
You certainly may. Okay, Attorney Lucy Williamson.
Good morning, Your Honor. I have an agreement. It's to prove up a divorce and it's with Edna Cedillo. And I know she's on. She was just the item.
Yes,
I'm here.
okay. And what number is that on the court's docket?
It should be number 2?
Yeah.
I'm sorry, 3.
Okay, F 2626-20-9, in the matter of the marriage of Cesar Juarez and Carla Gonzalez.
Good morning,
So
Your
you're
Honor. Lucy Williamson here for Carla Gonzalez.
And then Cedillo on behalf of Mr. Cesar Juarez, Judge. I did have communication with him this morning, but I don't see him on the screen, Judge. Oh, yes, I do.
Yeah. I believe they're both on the screen, Your Honor.
Okay, so are they English speaking or Spanish speaking?
My client is English speaking, Judge.
My client's English speaking, Your Honor.
Okay, Mr. Juarez, can you hear me?
You're on mute, Mr. Juarez. You need to unmute.
There it is. Yes.
Okay, and Miss Carla Gonzalez, can you hear me?
Yes,
Okay, can I please have you both raise your right hand? Do you swear that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
yes.
Okay, who's gonna be proving it up?
Your Honor, I'll read it into the record quickly.
Okay, go ahead.
Your Honor, if we can stipulate it as to all terms on the petition as to jurisdiction.
Yes.
Ms. Gonzalez, is it true and correct that you and your husband entered into an agreement?
Yes,
And is the agreement as follows, that you and your husband are to be appointed joint managing conservators of the children, with you being the primary managing conservator of the girls and your husband being primary managing conservator of your son? Is that correct?
that's correct.
And you're each going to have extended visitation with the children, with one party having first and third and the other having second and fourth. Is that correct?
That is correct.
And is it true and correct that all other holidays and summers are pursuant to the family code? In other words, you're going to divide them, even and odd.
That is correct.
your husband is going to pay you child support of $1,300 a month commencing September 1st, 2021, with a step down to $1,085 per month. Is that correct?
That is correct.
And he is to continue providing medical insurance and dental insurance on behalf of the children. Any unreimbursed medical expenses are to be split equally between the parties. Is that correct?
Yes.
And as to your property, each of you is going to keep whatever property in your possession, including vehicles and personal property. Is that correct?
Yes, that is correct.
And you agree that as to your husband's retirement, each of you be awarded 50%. Is that correct?
Yes, that is correct.
And that you will prepare any necessary orders to effectuate that. Is that correct?
That is correct.
You agree to pay any and all debt in your name, including a student loan, correct?
Yes, that is
And
correct.
your husband will pay any and all debt in his name? And he
Yes.
will pay off the vehicle awarded to you. Is that correct?
That is correct.
Okay. And is that your agreement, Ms. Gonzalez?
Yes.
And do you feel that this is in the best interest of your children?
Yes.
And do you think this is a fair and equitable division of the marital estate?
Yes.
And you entered into this freely and voluntarily, correct?
That is correct.
And you two are asking for a divorce, correct?
Yes.
And just for the record, Ms. Gonzalez, you only have the 3 children that are listed on this petition, correct?
Yes.
You and your husband did not adopt any other children?
No.
And you are not expecting a child at this time, correct?
No, that is correct.
All right. And you are asking for a divorce?
That is correct.
And you are satisfied with my services, correct?
Yes.
I pass the witness, Your Honor.
Okay, any questions, Ms. Cedillo?
Not of this witness, Judge, no.
Okay,
I would like an opportunity
go
to call.
ahead.
I'm sorry, Your Honor, I think I was cutting off. I'd like an opportunity just to question my client, Judge.
Go ahead.
Okay, Mr. Juarez, you heard what was read into the record by Ms. Williamson, correct?
Yes.
And is there anything different from our discussions or anything that was different from what you signed in the decree?
No.
Okay, and are you in agreement with the terms that as were read out by Ms. Williamson?
Yes.
Are you asking this court to grant your divorce?
Yes.
No further questions, Judge.
Okay, so
Your
yes,
Honor, and just for the record, we do have a signed divorce decree on page 33. There is a typographical error. Each party is to pay the debt solely in their name, and it's incorrect on the decree, but I'll address that with Ms. Edna to get that changed on that page.
Your Honor, and I think specifically that also didn't address the vehicle, but Mr. Juarez and I had that conversation. He does intend to continue payment on Ms. Gonzalez's vehicle, Judge.
Correct.
okay, are you putting that in the decree now that you're making that other typographical error change?
Yes, Your Honor, we are.
Okay. How old are these children?
Ms. Gonzalez, how old are your children?
17, 15, and 11.
Okay. Okay, because anytime that you split up the kids, I want to know what their ages are so that I can see if it is in the children's best interest, but I can understand in that age frame why you may possibly be thinking this is in the best interest.
Your Honor,
Now,
for the record, they have been split for some time like that, Judge. And the parents do work well together with the visitation, Judge.
okay, and that's what I was gonna say. At the end of the day, you all are parents, and that's what you want to be, is good co-parents. And my only concern will always be your children. It doesn't matter to me whether you all ever care to reconcile or not. I just care that you be the best parents to these kids, okay? So work well with each other. Try to give each other some grace in those situations when you run into a bump in the road. Remember that at the end of the day, your children you're always going to be their parents, and they will always look to you as an example to see how you treat each other And that'll be how they treat one another and other people. So, okay, the court will accept the agreement as read into the record and will further grant the divorce today. And I'll wait for you all to make those corrections, and then you can submit the divorce decree, and I'll just set a ticker for the 27th.
Yes, Your Honor. Thank you very much. I have nothing further before this honorable court. If I could be excused.
You certainly may.
Thank
Same
you.
announcement, Your Honor, may we be excused?
You certainly may.
Thank you, Judge.
Okay, thank you. Attorney Bobby Garcia?
Good morning, Your Honor. Bobby Garcia here for Imelda Reyes. And we've just got a status conference this morning, Your Honor. And the only thing that we've got to report to the court is that we've got a mediation on October the 18th. And we've got to make sure that gets done before we request a docket control conference if it's even needed. But we work really well with Omar Science and his law firm, and hopefully we'll get this thing settled.
Okay, what number is that on the court's docket?
39 on the docket, Your Honor.
Okay.
And good morning, Judge. This is Omar Sines, president for Walmart Stores Texas LLC. And
Okay.
everything Mr. Garcia just advised the court is accurate.
Okay, that's on CL-20-3409-I, Imelda Reyes versus Walmart Stores. Okay, and that mediation is going to occur on October the 18th, you said?
That is correct.
Yes, Your Honor.
Okay. Okay, then let me have you come back on October the 27th to let me know what happened.
Very well, Judge.
Yes, ma'am.
Okay, that'll be October 27th at 9:30 a.m., gentlemen.
Okay.
Thank you.
Thank you
Your
very
Honor.
much, Judge.
May we be excused?
You certainly may.
Thank
Okay,
you.
thank you, Your Honor. Have a good day.
Okay, likewise. Attorney Daniel Sorrells?
Good morning, Judge. How are you?
Good morning, sir.
Judge, I have number 11 on the court's docket.
Okay, CL 20-3480-I, Marcelo Herrera et al. Versus Laura Denise Hassel et al. Okay, go ahead.
Good morning, Your Honor. I'm Hector Torres. I'm appearing in this case as well. I represent Miss Laura Hassel.
And Judge, for the record, Judge Daniel Sorrells, I represent the plaintiff on this case. Judge, just by way of a little background, this is a case that will eventually be a friendly suit. Judge, we have entered into a settlement agreement subject to both the court's approval and also the ad litem's approval, who is Mr. Jose Ozuna. However, we filed lawsuits against all the medical providers for the minor plaintiff who have all been served, Judge. Some of those medical providers, we entered into agreements and we subsequently non-suited them. However, there are 5 medical providers that have not filed an answer, Judge. And so we're asking to proceed on a default against those medical providers to enter a judgment as to what is reasonable and necessary for the treatment of the minor plaintiff, Judge. Just also by way of a little background, this is a $30,000 policy, Judge. So what we're attempting to do is divide up $10,000 amongst all the medical providers. That way, the minor will have a good settlement at the end, Judge. And I have discussed that with Mr. Ozuna as the ad litem. He indicated to me that he would most likely approve of that, Judge.
Okay. Mr. Torres, I know your only interest is Ms. Hassel. Did you want to add anything else or?
No, Your Honor, we answered this lawsuit on May 17th, so I think we're okay for today.
Okay, so Mr. Sorrells, who are the providers that have not filed their answers?
The Judge, it is South Texas Health System, McAllen Hospital LLC, RFC Radiology Associates, Edinburgh Regional Medical Center, and McAllen Emergency Medicine Association.
You said South Texas Health Systems, McAllen Hospital, RFC Radiology, Edinburgh Regional Medical Center, McAllen Emergency Medicine Associates, and who else?
I believe that covers it, Judge.
That's only 4.
Judge, South Texas Health System, McAllen Hospital LLC, RFC Radiology Associates LLC, Edinburgh Regional Medical Center, and McAllen Emergency Medicine Association.
Okay.
That should just be 4, Judge.
Okay, so that, I'm sorry, what did you say?
It should be 4, Judge, if I'm counting correctly.
Okay, that's what I have is 4. Okay, so do I have anyone here from South Texas Health Systems McAllen Hospital, RFC Radiology Associates, Edinburgh Regional Medical Center, or McAllen Emergency Medicine Associates? Okay, I have no one that has answered. And service was perfected. I just find it odd that they would not file an answer.
Yes, Judge, service was perfected
Okay, on what date?
8 months ago, Judge. I'll get the exact dates here. On South Texas Health System McAllen Hospital, they were served on October 2nd, 2020. On RFC Radiology, they were served on October 15, 2020. McAllen Emergency Medicine, they were also served on October 2nd, 2020. And Judge, I think I had misspoken earlier. Edinburgh Regional Medical Center, Judge, that's in the same kind of bracket as South Texas Health System, Judge.
So you served them under that representative?
No, Judge, we just serve South Texas Health System. So we're not seeking a default against Edinburgh Regional Medical Center, and I don't have any bills from them, just from South Texas Health System, Judge.
Okay. Okay, then you may proceed. You want to just put what you need on the record?
Yes, Judge. We'd ask the court to take judicial notice of everything in the court's file.
Okay, the court will do so.
Judge, we would ask that that the reasonable and necessary medical expenses provided to Marcelo Herrera Jr., a minor from South Texas Health Systems, be set at $7,640.92. The amount from McAllen Emergency Medicine be set at $700, and the amount for RFC Radiology be set at $30, Judge.
Okay, what was the first amount? 7,000 what?
$640.92.
Okay,
And that's what we would ask the court to set at a reasonable and necessary amount for the medical providers that provided services to my client, Marcelo Herrera Jr.
okay. The court will so grant and find that those are reasonable medical costs. In your order, please be very specific as to the provider and the amount.
Yes, Judge.
Okay. And I also want you to put in that order, I know it's a little unorthodox, but please be specific as to the date that they were served and what their answer date would have been, or and how they failed to answer.
Yes, Judge.
Okay. Okay. Okay, anything else?
No, that's it, Judge. And I guess the only thing that we have left pending will be a friendly suit hearing. I'm not sure if the court wants to give us a date now, or if we should file an order setting hearing on that, Judge.
Okay, well, the court will grant your motion for default judgment as to those defendants named on the record that failed to file an answer within the required amount of time. And how much time do you need for that friendly suit?
Judge, in talking to Mr. Ozuna, he's already met with the minor, with the parents. So I think within 2 weeks, we should be ready, Judge.
Okay, the earliest I have is September 15th.
That's perfect, Judge.
Okay, September 15th at 9:30 a.m. for your friendly suit hearing.
Thank you, Judge. That's all I have. May I have excuse?
Yes, Mr. Torres, you may be excused as well.
Thank you, Your Honor. Have a good day.
Thank you, likewise. Okay, Attorney Jennifer Regalado.
Good morning, Your Honor. I have number 25 on your docket.
Okay.
And it's with Mr. Grime, who is also on.
Okay, that is CL 152390-I, Maria del Carmen Muniz versus Jose Guadalupe Berrones. And what is your announcement, Counselor?
Your Honor, unless Mr. Grime has some new news, my understanding is that the case is settled, but we're waiting on his client to sign off on the settlement documents.
Jeff Grime for plaintiff. Your Honor, I thought my client already had. I'm going to have to write heard on it. Everything's settled on this. I was just waiting to get everything in. I just haven't been in the office. I was quarantining for a few days there, so I wasn't able to follow up on this as well as I should have. But we'll get this together and done and get everything submitted your way in the next week or two.
Okay, so then since it's settled and all you're going to do is circulate the agreement, then what I'll do is I'll just set it for a tickler. I'll give you till August the 27th. And then if you don't submit it by then we'll have a show cause.
Thank you, Your
Yes,
Honor.
Your Honor. Thank you.
Okay.
I have no further business. May I be excused, Your Honor?
You certainly may.
Thank you.
Thank you. Attorney Carlos Galvan.
Good morning, Your Honor. I have number 22 on the docket.
Okay, CL 203322-I, Jose Humberto Ramos Rivera et al. Versus Andres Sainz.
Yes, Your Honor. Carlos Galvan for plaintiff. I believe Attorney John Schultz is standing in for Michael Guerra, Your Honor. And
Mr. Schultz? Do you see him on? I don't.
Apologies, Your Honor. I was
Yes.
on the phone with another court right now.
Well, Mr. Schultz, I don't recognize you. You cut your hair?
Yes, ma'am. I telling everybody I ended up getting too hot.
Okay, so what do we have, gentlemen?
Your Honor, it's defendant's motion to compel. I was conferring with Mr. Galvan. My understanding on our end, Mr. Guetta's understanding, we hadn't booked mediation deposition dates yet. Mr. Galvan is assuring me that the deposition dates had been confirmed for 2 of the plaintiffs. The problem child is plaintiff number 3.
Okay.
correct, Your Honor.
So I don't know how. I know the Mr. Galvan indicated that his office is trying to get a hold of this third plaintiff. The third plaintiff is who exactly, Mr. Galvan?
Jose Humberto Ramos Rivera. He's the driver.
And he's the one that you have not been able to communicate with to schedule the deposition?
Your Honor, as we let opposing counsel know, we even hired an investigator to look for him. It's our understanding that he's in Mexico at this time and cannot return for the time being. So we were going to continue to try to make contact with him, but as of this time, we hadn't been able to.
Okay, so
But
he's not even available then to do it via Zoom?
At this point, no, Your Honor. But we did get a hold of the other 2 plaintiffs who are his ex and his daughter. They're the ones that have kind of given us some information on him, but they did confirm dates with us, and we're going to be noticing those depositions today.
Okay, and when will those happen?
October the 12th.
Okay. Okay, Mr. Schultz, do you want to hold it over to see what happens if they show up, or? Because I can't force him to come from Mexico.
I understand, Your Honor. I think I think at this time, my understanding is the second hearing on this motion to compel. I think the best thing, the issue was that the dates hadn't been booked and confirmed up until now. So for now, if we could just, if the court's willing, if we can hold over and pass on the motion, let's see how the depositions of the 2 plaintiffs go. Obviously, there's going to be a future issue given that the driver of the vehicle, of the plaintiff's vehicle, appears to be the one that's
unavailable,
located. And through no fault of Mr. Galvan, but it is what it is.
Okay, then we'll come back on October the 18th at 9:30, and then you can let me know at that time what we're doing with this.
Great.
Yes, Your Honor.
Okay,
Thank you, Your Honor. May we be excused?
you certainly may.
Have a great day.
Okay, thank you. Okay, Attorney Elizabeth Garcia.
Good morning, Your Honor.
Good morning.
Item number 40 on your docket.
Okay, CL 210085-I Alejandro Castro versus Guadalupe Padron et al. And what is your announcement, Counsel?
Yes, good morning, Your Honor. I'm pleased to announce that we've been able to reach a settlement in this matter. So we're in the process of getting the appropriate documents signed and filed.
Okay, and do you need longer than August the 27th?
I don't think so.
Okay, I can set a tickler for August the 27th. And if it hasn't been submitted by then, we'll just contact us and let us know so I don't set you for a show cause. If you need a little bit more time, I'll extend the time.
Okay, yes, I know that the plaintiff's counsel is attempting to negotiate some liens. So I don't know what the status is on that, just that, you know, we've agreed to allow them time to work on those liens.
Okay.
Okay.
All right, then we'll just set a tickler since it's been settled.
Perfect. Thank you. That's all the business I have today. May I be excused?
You certainly may, ma'am.
Thank you. Have a great day.
Likewise. Attorney Rene Castellanos.
Good morning, Rene Castellanos on cause number CL 15-4382E. I believe it's number 27 in the court civil docket.
Your Honor, Francisco Zabarte here on behalf of the City of San Juan.
Okay, that is Pedro Valdez Jr., Elizabeth Valdez versus City of San Juan and Cynthia Ramirez Castillo. Okay, go ahead.
Your Honor, we had gone to mediation. We were not able to settle the case at mediation, and the court had told us to come back for a status conference. I may be filing a dispositive motion, but other than that, I think we can probably have a DCC to set it for trial.
Okay, so I mean, of course, it gives you an opportunity to continue talking because the reality is that you won't be in trial for this case till sometime next year. And the two factors that go into that are one, obviously what's going on with COVID and the jury panels. I don't know if y'all have had an opportunity to listen or see the last Board of Judges meeting where we had been hopeful that we would be able to start doing some in-person trial settings very soon, but that has now been tabled. And so we will not have anything in person in all likelihood all the rest of this year. So what I'm forced to do is set you out until next year so that we can see where we will be at the beginning of the following year. And then also we need to see where we are with the courthouse. So it doesn't mean you don't have to talk anymore. I encourage you to continue talking because it'll also depend on how badly you all want this to go away.
And I, for the record, I have reached out after the mediation a few times to Mr. Castellanos. We're hopeful that something can be settled.
Okay, so I'll have you return on January the 31st at 9:30 a.m. And I will continue to be hopeful as well.
Judge, I'm sorry, that's just for a status hearing, 131?
Just for a status.
Okay.
Because I'm not giving DCC dates right now. Because I
Very
wouldn't
well.
know when to set you.
We'd be happy to try this to the court, Judge. We'd waive a jury.
Oh, you want bench trial?
I'm fine with that. I don't know if Mr. Zabarte would be fine with it.
I don't have the authority to agree to that, Your Honor.
Okay. Why don't we do, we'll leave it for January the 31st. If y'all confer and you do want a bench trial, we'll give you a DCC and we'll set you up for a bench trial.
Okay.
Very well.
So
No
for
VHP,
now,
so.
we'll just do that.
Thank
Okay.
you, Judge.
All right, thank you. You
Thank
may
you,
be
Judge.
excused.
Thank you.
Did you see my eyes light up with, oh, you want a bench trial? Sure, we'll get that done, you know? Okay, you all be safe. All right, Miss Orellana?
Good morning, Your Honor. I'm here on number 30.
Okay. That'll be CL 180788-I Luis Cisneros versus Nora Gallardo et al.
This is the opposing counsel, Your Honor, on this one.
Yes, Your Honor. Good morning. Lisa Vasquez Garza on behalf of the defendant.
Okay, and what are the announcements, counselors?
Judge, this is one of yet another one of your older cases that you've inherited. We were waiting for some, we had previously gone to mediation a while back, well before this court inherited this case. And in our last hearing, I had mentioned to the court that one of the issues was one of the plaintiffs had since been declaring that he was disabled. Looks like we got some records, but unfortunately the records were incomplete, as all they did was submit medical records, but not necessarily the intake information, what Social Security decided, and things of that nature. And I'm not even optimistic that I will get them, Judge, just by the nature of bureaucracy in the government, and was a challenge just getting these things that I already had. So, you know, we can either just continue to see what we can do to visit informally, see if we can bridge the gap from the last mediation that was several years ago. If the court wants us to wants to order us to go back to mediation, we'll do that. You know, I don't want to announce to the court that all our efforts to resolve the case have been exhausted, but we have tried. And this information, you know, the information provided was to be desired because it was information I already had.
Okay, Miss Orellana, do you want to add anything to that?
Yes, Your Honor. On this one, we mediated back in June of 2019. That at that mediation, both of us were notified that my client, I don't recall if he had applied for disability or had already been granted disability. So those records that Ms. Vasquez Garza has been trying to get is since 2019. Seeing the position that we find ourselves in due to COVID, I don't know how much of it is to either, put a deadline on her trying to get these records. It's been over a little bit over 2 years since we've had this information. Without that information, I don't know that going back to mediation would be beneficial, just because Ms. Vasquez Garza has mentioned that she needs those records in order to mediate on a good faith basis. I have reached out to her. I have reached out to her adjuster to see if there's any way that we can attempt to bridge that gap from mediation. I haven't gotten any response, no new numbers, no new information, other than that they're still waiting for these records.
Okay, so then are you needing these records to move forward, or can you move forward, get enough information to comfortably move forward? You know, because you may just be waiting and waiting and waiting, and who knows how long.
I agree, Judge. I mean, it just the record's clear. It's not for our lack of trying. I mean, we've been trying to get these, and unfortunately, then they wanted particular releases. Then we had to file motions to compel on that, and it's just, then they wanted a different release. We had to get another release, and so we've gotten all the different releases. At the end of the day, Judge, the issue is going to be whether or not this accident resulted in any sort of disability, and clearly Ms. Orellana is going to say it is, and clearly I'm going to say it's not. And, you know, we may just have an impasse. So we had been set for trial previous times before, where I think we had both announced ready. And then, you know, this issue came up. So while I'd like to have them, you know, this case is not going to stay on the court's docket forever. So we've reached out to the record folks to say, this is not the entire information. And apparently that's all the disability folks were going to give us. So I may have reached a dead end.
Okay. So then, and this is something that you all would be asking for a jury trial?
Yes, Your Honor.
Yes, Judge.
So then have you already reached the end of the road? Then are we just ready to set this for trial?
Judge, like I said, we have gone back to them. I'm trying to see what else, what they gave me was documents I already had. And it wasn't, so what I was trying to see, when he went and filled out, I'm disabled, what did he say the reason for his disability? All they did was just give me records that I already had. It wasn't it wasn't what his position was, because there's plenty of information that he had lots of issues prior to this accident. There was no documents from the disability, what their findings were. All those documents, which I believe are integral, were not provided. It was just medical records. And medical records that I had already discovered either directly or that was given to me directly by plaintiff's counsel, or that I discovered independently. So, I don't want to be in a position where the court says you can't try any further. Obviously, there's rules of procedure that would dictate it once there's a DCO in place, because I still want to see if I can gather that information. But in terms of anything else, that's the only thing that would be lacking with respect to our case, Judge.
Okay, well, why don't we do this? We already know we're not going to trial this year. So why don't we just have you come back on January the 31st? Between now and then, you still have that time that hopefully you can get something. And if not, then we'll move forward with a DCC, and hopefully we'll know what we're going to be doing at that point with jury trials. That's the best that I think that we can do. And that way we're not setting you for a conference every few months just to have you make the same announcement if there's no progress that's made. Okay? So we'll have come back on January the 31st at 9:30, and let's see what happens between now and then.
Yes, ma'am. That's all I have. May I be excused?
Yes.
Thank you.
That's all, Your Honor. May I be excused?
You certainly may.
Thank you. Have a good day.
Likewise. Okay, Attorney Heather Abreu.
Thank you, Your Honor. Sorry about that.
That's okay.
I have number 35 on the docket.
Okay. That's CL 193318-I, Edwin Valdez et al. Versus Eduardo Estrada. And what is your announcement, counsel?
Yes, Your Honor. We have resolved this matter. We've settled this matter. We've entered into a Rule 11 agreement this morning, and everything will be, the settlement agreements, everything will be forthcoming.
Great. Okay, so do you need longer than August the 27th?
No.
Okay, I'm just gonna set a tickler for August the 27th. If something happens to get you stuck, just let us know so I can put you a little bit further so I don't set you for a show cause.
Okay.
Okay. Anything else?
Thank you, Your Honor. This is Victor Quintanilla. I represent the defendants, and I appreciate that, Judge. 9:30 on August 27th, Your Honor?
No, it's just a tickler. It's just for me. Since you all settled, I just want to make sure that you all submit the documents.
All right, perfect. Okay, Your Honor. We'll get that done, Judge.
Okay, perfect. Thank you all for the settlement.
Thank you. May we be excused?
You certainly may.
Thank you, ma'am.
Thank you.
Thank you. Attorney Dan Mora? Mr. Mora? Okay.
Judge.
Attorney- Yes.
I'm on a case with Mr. Mora. There it is.
Okay, Mr. Mora?
Yes, Judge.
Good morning, sir. What number on the court's docket?
Number 21.
Sir, congratulations on your son.
Thank you.
As we're sending ours off for our first day, you just graduated yours from college.
I've got them on all stages, Judge.
That is F 4689-20-9 in the matter of the marriage of Ninfa Longoria Alvarez versus Macario Alvarez.
Good morning,
Got it.
Madam.
For Ninfa Alvarez.
Okay, one at a time.
Sorry, Judge.
Go ahead, Mr. Mora, you can announce who you're representing, and then we'll have Ms. Fuentes Aguilar announce.
Dan Mora for Ninfa Alvarez.
Diana Fuentes Aguilar from Macario Alvarez, ma'am.
Okay, and I think you just had some issues to iron out from the last time. Were you able to do that?
Judge, and I need about 2 weeks. We've got the decree, everything's done. I have they're almost 80 years old and she's not tech savvy, and I have to communicate with the children. We got to go back and forth. I've already forwarded the divorce decree. I think everything is in line. I spoke to the daughter this morning, and the reason my client's not on is there was nobody at her house to get her on Zoom. Everybody's at work. So if I just get 2 weeks, I'll get her to sign it and we can submit it, and that'll take care of it, Judge.
Okay, Ms. Fuentes Aguilar?
Yes, Your Honor. This is a motion for entry, and bottom line, we just need to get the signatures. They are older people, and luckily my client's here. Mr. Mora has his client out of state, but I'm okay with the 2 week recess.
Okay, then we'll just come back on August the 30th at 9:30.
Thank you, Judge.
Your Honor, if the decree is filed by then, do we need to appear?
I don't recall that they testify. Oh, there are no children. And then is there property? Aren't you all dividing some property?
That's been done.
Okay.
That's been done, Your Honor. We did the prove up already. We just need to finalize the decree.
Okay, then just submit the decree once you have everyone sign off. And if you do it prior to that date, you don't need to show up for that hearing.
Thank you.
Thank you, Judge.
Okay. Anything else?
No, ma'am.
All right.
No, Your Honor.
Okay, stay safe. Okay, Attorney James Sahadi.
Good morning, Your Honor. I have numbers 36 and 42.
Okay, CL 196266-I, Maria Matilde Cardenas versus Stuart.
James Sahadi, on behalf of the plaintiffs.
Okay.
And I did.
I'm here, Stephen Hudgens for the defendant.
Okay, and what is the announcement, counselor?
Judge, we're here on status.
Okay, so then we already resolved the issue with respect to discovery?
I'll leave that up to.
We're just in the same position we were last time, Judge. I don't have any medical records or bills, and so if he doesn't want to produce them, then.
Well, I think that part of that issue had been resolved, Judge. We had provided a medical authorization.
But I still don't even know the amount of the bills, Your Honor.
Yeah, the issue is, it's not that it was resolved. It's just that you all are still in disagreement as to whether a medical authorization is sufficient.
Oh, I apologize.
Yeah, and then we just said we take it up at trial just to see if it was admissible or not. So unless you all come up with something. So then are you announcing that you're still needing a jury trial setting?
Yes.
Okay. So then if you'll be doing that, then I'm going to you already heard the same spiel that I gave everyone else. So I'll just set you for January the 31st at 9:30. And I'm very optimistic that at that point we can be able to move forward.
And Judge, I would be okay with a bench trial. I don't know if defense counsel would be okay with that.
I don't know, Mr. Hudgens. Okay, I was going to ask if you had authority to.
I don't, and I'm the one who demanded the jury trial. So and generally we do jury trials in these kind of cases.
Okay, then January 31st at 9:30, and if anything changes, just notify my staff.
Thank you, Judge.
May I be excused? I know Mr. Sahadi has another one.
You certainly may.
Thank you, Your Honor.
Okay, and then Mr. Sahadi, you said what other number?
Yes, number 42, Judge.
Okay, CL 210915-I, CDOT Gutierrez et al. Versus Shell Point Mortgage Servicing.
Yes, Judge. Just an announcement that the case, of course, had been removed to federal court. I can announce that it looks like we've reached a settlement. Anticipate exchanging settlement documentation and then non-suiting the federal case. And of course, we'll immediately non-suit the state case as soon as the federal case is finalized.
Okay, and more or less what time frame are you looking at?
I'm thinking it shouldn't take more than about a month.
Okay.
I don't know what the federal court may require of us, but I wouldn't think more than about a month, Judge.
Okay, since you're not going to require a further hearing, I'm just going to set a tickler for September the 24th, and then we'll see where we're at that point.
Thank you, Judge. May I be excused?
You certainly may.
Thank you.
Okay, thank you. Attorney Jorge Rubio.
Good morning, Your Honor. I'm here on number 38 on your docket, CL 20-0511I. George Rubio on behalf of the plaintiffs.
Okay, Ernesto. I'm sorry, who's on behalf of the defendant?
Good morning, Judge. Damon Garcia on behalf of the defendant.
Okay, I inadvertently interrupted you. Okay, that's Ernesto Moreno versus Francisco Javier Chavero. And what is the announcement?
Actually, Your Honor, it's Ernesto Moreno and Berta D. Moreno versus Francisco Javier Chavero. I think a DCC was filed on this. We went to mediation a while back, but we're still talking. Hopefully we can get some movement. I think my clients are the ones that need to respond, so I'll get that done. Other than that, other than a few depots, we would be ready for trial. We've already heard the court advise us, and I think we could get set for a second status on January 31st, and hopefully either we'll have it resolved or at that point we'll ask for a DCC depending on what's going on at that time.
Okay. Mr. Garcia, anything else to add?
No, Your Honor.
Okay, then, and you already attended mediation, is that correct?
We have, Your Honor, and I think we've even talked after that, and we'll continue to talk, and hopefully we can get the case moving one way or the other.
And what about the rest of discovery? Depositions done?
I think I just have to take the defendant's depo, and then obviously depending on when we're going to trial will depend on whether or not doctors and experts are available. So that's kind of up in the air until we can have an actual trial date to know if they're available or not.
Okay, then we'll do that. I'll have you return on January the 31st at 9:30 a.m. And let's see where we're at that point.
Thank you very much, Your Honor. That's all I have in front of this court. May we be excused?
Yes, you certainly may. Thank you.
Thank you.
Okay, Attorney Jesus Contreras. Mr. Contreras?
Your Honor, I'm proving up a divorce in Williamson County, Your Honor. Can you recall this case, please?
Sure.
Your Honor?
Just
All right,
let us
appreciate
know
it.
when you're done.
Thank you so much.
Okay, Attorney Miguel Weiss?
Yes, Your Honor, I apologize.
That's okay. What number, sir?
I don't have the,
We're 32, Your Honor, on your docket sheet.
Okay, thank you.
thank you, Hannah.
Okay, that would be CL 190544-I, Edith Trevino versus MMCTG LLC et al. Okay, and what is the announcement?
Your Honor, Miguel Wise is present ready for this status hearing.
Good morning, Your Honor. My name is Carla Cesar. Good to see you. I'm here for MMCTG.
Good morning, Your Honor. I'm Hannah Sampson for Sergio Saldierna and Crystal Leos.
Good morning, Judge Attorney Albert Barbosa representing Irais Venegas and Edmund Gomez.
Okay, and let me know what's going on with the case.
Well, Your Honor, we're in the settlement phase in this matter. It's not complete. There's still some negotiating going on. I've contacted a third-party real estate expert that'll help us untie some of these knots that we have in the property transfers. What we really need is just a continuance, giving us a little bit more time. At least that's on the part of the plaintiff. I believe that Ms. Sampson has some other requests of the court.
Okay, Ms. Sampson?
Yes, Your Honor. I'm not opposed to the continuance, of course, and I understand all of the difficulties the court is going to have rescheduling lots of cases, but we were in County Court at Law number 5 first, and on January 6, 2020, there was a motion to compel discovery. The notes indicate that it was granted, but Judge Cantu never signed the order that's sitting with the court. So I would just ask that we can get that order signed, because while we do hope to settle, we also, of course, want to move forward with discovery so that that doesn't become a delay later.
Okay. What date did you file the order granting?
It was filed on January 10th, 2020.
Okay.
And Your Honor, if I,
Go ahead.
I'm sorry to interrupt. I just wanted to say on the record, as far as this order is concerned, I had originally filed the motion for protective order. And the reason was, these are residential lots. So they could be construed, the underlying loans could be construed as consumer debts. So I didn't want to run afoul of any, consumer protection laws, which would subject my client to additional liability by producing all this information. That being said, I believe the protective orders agreed to the documents they're requesting that we produce all belong to clients of the attorneys who have agreed to this protective order. And so based on that, we're not, obviously the court has already indicated that it's granting the protective order that's been submitted. So, I just wanted to clarify the reason for the protective order and why we're requesting it.
Okay, but, and you filed your motion for protective order. Did you also file the agreed order?
I did not sign it, Your Honor. I'm not the one who drafted that particular order. Mine.
Actually, Mr. Izaguirre did draft and file the order. So the order was submitted after the hearing. And I do think it's true that it's not signed by the parties, but it was Mr. Izaguirre that's submitted the order, and I'm not opposed to a protective order, of course.
Okay, I'm sorry. I thought you were talking
I
about.
obviously have no issue with a protective order. Yes.
And I'm sorry. I thought you were talking about the one that you had drafted and circulated.
I had drafted that. We're waiting on one signature on that one. But the order does include a protective order. It's not as robust as one that I subsequently circulated, but if Mr. Izaguirre is fine with it, then I'm fine with it. I just want the discovery order to be signed. It's a combined discovery order with the protective order, just for clarity, Your Honor.
Okay, so then the order that was filed on January the 10th, 2020, that order has the order granting the motion to compel and the protective order language.
Yes, Your Honor.
Okay, so are all of y'all in agreement that that's the order that you're looking at me to sign?
Plaintiff is in agreement.
Okay. Mr. Barbosa?
Yes, Your Honor.
Okay, and Ms. Sampson and Mr. Izaguirre already stated yes.
I think, sorry, Your Honor, I'm realizing because the order's from so long ago, the order is to produce discovery by a date in January of 2020. So I'm amenable to 30 days, whatever Mr. Izaguirre feels like he can comply with, just so that we're on the same page, because the date will be wrong on the order.
Okay, and that order that was filed on the 10th, does it have everyone's signatures? No?
I don't.
Okay.
No, Your Honor.
Circulate a new order if you would prefer.
Okay, well, no, what I can do, but you must state it on the record, that I can just cross out that date and I will just state 30 days from the date that the order is signed.
No objection from plaintiff.
Statement as Your Honor.
No objection from MMCTG, Your Honor.
And no objection from me, Your Honor. Thank you very much.
Then I'll go ahead and do that just for the sake of, judicial efficiency, and we can just get that going. Okay, so now that we have that out of the way, what's next?
I think it just depends on how our settlement discussions go, Your Honor. It's a title dispute that arose when some lots were allegedly marked incorrectly. One of the plaintiffs or one of the parties began construction on a lot that didn't belong to them. There was no survey done prior to the construction commencement. So what we're trying to do is exchange lots so that everybody can be happy. And I think we've agreed to that. We're just, there might be some additional negotiations concerning damages.
Okay, so what we'll do is, since I'm just hearing this for the first time, I'm going to get that order forward it to me. I'm gonna sign off on it. You'll have the 30 days from that date to produce. Then I'm gonna give you an opportunity to review it, okay? So then we're gonna come back here on October the 18th, just for a second status. And then at that point, we can see what our next step is gonna be.
And that is October 18th, Your Honor?
Yes, at 9:30 a.m. Okay,
Thank you very much.
Thank you, Your Honor.
okay. Do you all have anything else?
No, Your Honor.
May we be excused, Your Honor?
We certainly may.
Thank
Be
you.
safe.
Be safe.
Thank you, Your Honor. Have a good day.
Thank you, likewise.
Thank you, Your Honor.
Okay, Mr. Schultz, I apologize. I didn't know you had another case. What other case do you have, sir?
That's fine, Your Honor. I am also covering on, boo. I've lost it, Your Honor. It's CL 15-2834-I, Blanca Estrella Barrientos versus Shinshi Chin. I'm actually covering for Mr. Michael Guerra, who will be taking over this case for Mr. Hernandez.
Okay, and I do believe I have Ms. Cedillo also on.
Good morning, Your Honor.
Good morning. Okay, and what is the announcement?
Your Honor, this case was, we're set for status following up on a mediation. We were unable to get this case mediated. Mr. Hernandez has left our firm, and the juggling of trying to find a replacement for him in time caused a scheduling issue. Since Mr. Guerra is going to be taking over this case now, we can get the mediation scheduled. The additional issue is going to be that Ms. Cedillo served some additional documents to us. We're going to need some time to review. And our admin, who's responsible for calendar all this, is out on maternity as of Friday. So we are asking the court, and Ms. Cedillo and I discussed this, we're asking the court for an additional 120 days to schedule mediation to allow for the additional time to review the documents that Ms. Cedillo sent us, as well as to shuffle through the confusion of how this is going to get scheduled. I know that our firm is having somebody cover for our administrative assistant, Laura Villanueva, but I'm not entirely sure how overwhelmed that person is going to be because they have other duties in Dallas.
Your Honor, if I may also, Mr. Schultz is pretty much correct in the announcement that he formally made. The only difference is that we actually just received the missing hospital documentation that had put off the mediation in this case, and we're getting ready to supplement it to opposing counsel so that way they can have that documentation. But also the reason why we're asking for extended time is because we want to make sure that we mediate this with the court-appointed mediator, Ms. Carranza, that was appointed to us by Your Honor.
Yes, that is who you'll mediate with.
Yes, Your Honor. We're well
Okay.
aware of that. It's just that it's kind of hard to get a scheduling mediation with three lawyers within less than 4 to 5 days.
I understand. Okay, 120 days is a long time. I don't know how Ms. Cedillo feels about that.
Your Honor, we understand that new counsel has come on to this case in regards to defense. So we understand they're going to need time to get familiar with this case. We'd rather that it be someone familiar with the case and also can inform their adjuster or their client so that way best decisions are made, because we'd hate to quickly mediate this and then not all facts be consideration. We understand there's special exceptions regarding this case. If the parties are able to mediate even sooner, that would be great. And I'm pretty sure that's what the parties are going to reach for, since we also understand that this is a case that's been on the docket for quite some time. But we respectfully understand that when new attorneys come into place, it takes time to get caught up to files.
Okay. Well, I'll go ahead and allow for y'all to come back on January the 31st. Let me know what happened. That's right after your 120 days that you requested. So it's January the 31st at 9:30. And then hopefully you all will have it all sorted out by then.
Yes, Your Honor.
Yes, Your Honor.
Anything else?
No, Your Honor, that concludes my business in front of this court. May I please be excused?
You certainly may. Mr. Schultz?
Nothing further at this time, Your Honor, may be excused as well.
Certainly may.
Thank you, ma'am.
Thank you. Okay, Mr. McCallum?
Good morning, Your Honor. Just unmuting. I have number 8 on your docket, Your Honor. I think Ms. Rose Sandoval is on the other side. It is Julio Quintanilla and Daria Quintanilla versus Allstate. I represent the plaintiff. The case number is CL 1588I. This is a case that's an appraisal, Your Honor. I spoke to my appraiser. I think the last part that needs to be done is we need to give payment to the umpire in the case. I think that's the final thing, and I don't know what his decision will be, but I think that would close it out.
Okay, that's number 24 on the court stuff.
Oh, 24? Okay, then I'm sorry. Oh, sorry. Yes, 24, Your Honor.
You do have number 8, but we're talking about number 24 right now.
Yes,
Okay,
yes.
and Ms. Sandoval, do you have anything to add?
Well, Judge, this case has been an appraisal for quite some time. We, on behalf of Allstate, paid the umpire's fee back in March of 2021. I think when you were here last in June, it was the same situation, as that we were waiting for the plaintiff to pay their portion of the fee. This case has been pending since 2015. The appraisal's been pending for close to 2 years. I mean, I don't understand why it's taking so long for the plaintiff.
Yeah,
to
Your
pay
Honor,
the
I
fee.
think it was just an accounting thing on our behalf. Like I said, if I could just have 2 weeks, I'll get that paid by Friday. And then we can make an announcement to the court once we get the award, and we can move on from there.
Okay, so then it is going to get paid.
Yes, Your Honor.
Okay, then y'all come back on September the 15th at 9:30.
Okay, perfect, Your Honor.
Okay, anything else?
That's all I have, Judge. May I be excused?
You certainly may.
Thanks.
Okay, and then you have CL 173652-I, Raul Martinez et al. Versus Southern Vanguard Insurance et al.
Yes, Your Honor. I don't know if the attorneys on those cases are here, but it's a case. It's a little bit. We had resolved the case with Southern Vanguard, and there's a new insurance that was served earlier this year. I don't think they've filed an answer. So I did speak to the attorney on that case. So I just like to see if I can get some more time to reach out to her and see what the issue was with them filing an answer.
Okay,
Because
well,
I
then
did.
just come back on September the 15th at 9:30 as well.
Perfect, Your Honor.
Okay, and let me know by then.
I will. And that's all the business I have before this honorable court, Your Honor. May I be excused?
You certainly may.
Thank you, Your Honor. Have a good day.
Okay, likewise. Okay, Attorney Eddie Trevino. You're on mute, Mr. Trevino.
Your Honor, good morning.
Good morning, sir.
I have number 13 on the docket, CL 21-2419I, representing John Abraham. I believe Mr. Monades is on too.
Yes, Your Honor, I'm here as well. Carlos Monades on behalf of Jason Muniz.
Okay, what is the announcement?
We have an agreed Rule 11, which we have both signed, and it should be in the court's queue.
Okay, and that's to settle the appeal?
Correct, Your Honor.
Okay. Okay, then I'll look for that. Then I'll see if it's already been accepted and forwarded to me.
Thank you, Your Honor. That's all I had.
Okay, Mr. Monarez?
That's correct, Your Honor. We've executed that agreement today. It's already been filed. I saw it on the email notifications. I just don't know if it's already been uploaded to the court's queue, but this matter has been settled.
Okay. All right. Well, that's good news. All right. Y'all take care and be safe.
Likewise. Thank you, Your Honor. If we may be
Thank
excused.
you. Yes, everyone may be excused
Thank
on
you.
this
Thank you.
case. Okay. Mr. Arredondo?
Yes, good morning, Your Honor. Edelmiro Hernandez, present for Leslie Robles. I believe on this case, Judge, Ms. Flores has an announcement.
Good morning, Your Honor. Sarah Flores on behalf of Mr. Michael Castillo,
That's number
Okay.
43 on your docket.
Thank you. F 2783-21-9 in the matter of the marriage of Michael Castillo versus Leslie Robles. And what is the announcement?
Yes, Your Honor. In this case, we did receive a custody evaluation, and I believe that Mr. Arredondo wanted 1 week to discuss it with his client so that we can see if we're able to resolve it according to the evaluation. We're in agreement to go along with it, but we want just a week to go over it before we resume a hearing.
That is correct, Judge.
Okay. The only issue, unless it's going to be agreed to, it would have to be September 15th. If you know that it's going to be agreed to, I can set you for August the 30th because I'm very stacked that day.
Okay. Mr. Arredondo, I think we're in agreement with it, but I don't want to speak for him. So I don't know if.
Your Honor, I just need to run it by my client, Judge, before. I don't want to misrepresent anything to this court, Judge, at this time, Your Honor. I mean,
Okay.
Unless we can, I'll talk to Mr. Flores' office, Judge, this week and to my client as well. And if it's an agreement, I can contact this honorable court, Judge, so we can set it up for the August 30th, Judge.
Okay, for now, we'll do September the 15th at 9:30. And if it's agreed to and ready for prove up, then let us know and we'll put you on that August 30th docket.
That'll be fine, Your Honor. Thank you.
Okay,
Judge.
I have nothing further. May I be excused?
you certainly may.
Thank you. Have a
I
good
may
day.
excuse, Judge.
You certainly may.
Client as well. Thank you, Judge. Have yourself a great day, Judge.
Thank you, likewise. Okay, Attorney Nereida Lopez Singletary.
Good morning, Judge. This is Helpa Singletary. We are here number 44 under docket that it's F 2799-21-9. I represent Mr. Adrian Cardosa. Mr. Adrian Cardosa is also logged in.
Okay, and I haven't seen Ms. Bettis log in.
Well, Your Honor, we have Ms. Perez has been substituted or been replaced now by Mr. Judge Jesse Contreras, and I saw him earlier log in.
I'm back, Judge, from Williamson County. How you doing,
Okay.
Judge Singletary? Good morning.
Good morning,
Judge,
and what is the announcement?
I filed a continuance, Judge, because I just fell into this case most recently. And I know there was set up a mediation outside my schedule with the other lawyer. And I just want to get a chance to speak to Judge Singletary and perhaps work out. I think we're going to end up working out an agreement at the end of all this mess, but it may be informally mediated to save some money. But I'm asking for some more time so we can do a DCC so we can look at our schedules and set up pre-trial and trial settings, Your Honor. But I think I anticipate that we'll work out an agreement during the course of this litigation, Your Honor. That's what I anticipate. But today I just need more time to get into this case, Your Honor. This was a prior hearing, Your Honor, that was set up before I got into the picture, Your Honor.
And just briefly, Your Honor, history, this is a case that came about for a TRO that was signed back in June. I worked with Ms. Catherine. We were set up for a contested hearing. We were able to work it out. And I am sure that Judge Contreras and I can get it resolved. There's only one issue, Judge. As part of that Rule 11, we have paternal mom supervising. She is not going back to school next week. She is a teacher, which is not going to be able to work out this agreement. So, and we did have mediation last Monday. It was canceled when Judge Contreras came on. So all that we're asking, Judge, is a short deadline for our mediation. And if we can't get it resolved, coming back, since I do not want my client not to be able to visit his children due to his mom going back to work as a teacher.
I think
Okay,
by
so-
tomorrow, Your Honor, we should have an agreement to that concern that Judge Singletary has, Your Honor. We'll be able to resolve that issue today and tomorrow.
Okay, so I'm very familiar with the order that was agreed to at the prior hearing. So if that's going to continue, that's fine. And if the only issue is going to be who will temporarily supervise, then I want that issue worked out within 48 hours. Okay, so who will be supervising will be worked out within 48 hours. I'll give Mr. Contreras an opportunity to familiarize himself with the case and see if you all can continue to talk. And I'll have you come back here on September the 15th at 9:30.
Your Honor, may we submit something within 40 hours regarding Judge Singletary's concern? Maybe a modified Rule 11 for right now. Again, if we work out that issue, Your Honor, within the next 48 hours, can we do that with your permission?
I will leave that up to your professional discretion, but I have
Okay.
no issue with accepting anything like that, just so that we make sure that we're all on the same page in case something comes up for enforcement.
Yes, Your Honor.
So, but hopefully on September the 15th, we can prove it up, and that'll be at 9:30.
Is that on a status basis slash?
Your Honor.
Well, I'm gonna leave it as a status for right
Okay,
now,
Judge, okay.
because I'm not gonna force you to enter into a final agreement. So I'm gonna leave it as a status.
All right.
If you're ready for prove it, well, you prove it up.
Yes, Your Honor.
And Judge, the only other thing is there a date earlier in case we cannot come into an agreement? Because I don't know who we're gonna have to supervise this. Mother works, maternal grandmother works, just in case there is an issue. Can we have an earlier date to come back for this court? And we're also going to mediate. Judge Contreras, if you're in agreement, we had agreed on Edna Cedillo. If you're okay with Ms. Cedillo mediating this case, Judge?
I got no problem. Secretary.
Okay.
No.
Yeah, you're saying because your concern is if y'all don't come up with an agreement in 48 hours, he won't be able to visit next week.
Yes, Your Honor, that's my concern.
Okay.
Well, Judge, we can keep September 15th and give us a tentative date, maybe early next week, so that in case we don't work out within 40 hours, that
If
issue.
it-
Your Honor.
If it's going to be only that issue
Yes,
as
Your
to who's going to supervise, then we can do it on the 19th, on Thursday at 4 p.m. Only for that issue.
If we work it out, Your Honor, we don't have to.
Correct.
Okay, thank you.
If you all work it out, then you won't need that 4 p.m. setting.
Thank you so much, Judge.
Thank you, Judge.
And Judge Secretary, I'll call you within the next 48 hours so we can see we can work actually today, later on this afternoon. I got a federal court hearing in Brownsville, Judge Secretary, that I gotta be there 1:30 in person, but after that, I'll call you, okay?
That's fine, Judge. Well, call me anytime you're done. Okay, thank you, Judge. That's all that we have.
Okay, you may be excused.
Thank you.
Thank you. Attorney Tim Davis?
Good morning, Judge. Tim Davis, number 14 in the docket, the matter in the marriage, Norma Trevino and Ernesto Trevino.
Okay, that's F0025-21-9, and Mr. De Luna had been logged in. I don't know if he's still here.
Yes, I saw him. I see him there.
Okay, and what is the announcement, counselors?
Well, Judge, I think we were actually set on your docket for a default because it was a waiver, but then Marco filed a notice of appearance back right about the end of July. I understand that the parties have kind of informally worked out the divorce. However, Judge, there are some assets that obviously need to be identified. So I would just say if we could get the case reset to give us time to do our required disclosures, which should cover everything as far as discovery, assuming, they're in agreement, and then we can come back and get it finalized.
Okay, Mr. De Luna, anything to add?
That's correct. I just came in more as Mr. Trevino's a friend of my, Judge. I just came in to make sure. I was told that there was some kind of informal agreement that had been agreed to. And looking at the proposed decree, there's a lot of generality when it comes to assets themselves, like Mr. Davis says. And just as I just need to protect my client and make sure that we, instead of being generalized, that we get specific on some of the assets that are going to be transferred back and forth between the individuals. I don't see this at all being a contested divorce at all, Judge, to be honest with you. I think it's more what Mr. Davis and I just need to figure out is getting specifics when it comes to the division of the marital estate itself, Judge. But
Okay,
I don't think there's any contention at all between the individuals. I think everything is going to be worked out on. It's more just making sure that the agreed, which will be an agreed order, is just specific when it comes to assets, just not just the generality of it.
Is there just property, or do they also have children?
There's 2 children, Judge, and I think that's like 100% in agreement what they're going to do on that issue. But like Mr. De Luna said, there's at least several financial accounts, retirement accounts that we need to specifically identify and find out, the values and things like that. Then the marital residence, I understand they've agreed to sell it.
Okay, so let me ask you, are you going to be conducting formal discovery or informal discovery?
Well, I think now under the new rules with the required disclosures, really, if we can exchange that information, I think it'll be more than sufficient as far as identifying the accounts, the real estate holdings, things like that.
There's and just when it comes to that, I don't mind getting with Mr. Davis and maybe doing not a per se an informal mediation, but just an informal meeting where we can get the clients together and try to work everything out and turn over documents that we need to finish the case itself.
Okay, so
I don't see this case being contentious at all, Judge. I mean, they're on good terms. It's just a matter of protecting both our clients and being specific when it comes to the disposition of the assets, the marital estate in this case, Judge.
Okay, so do y'all need more than 30 days?
I don't believe that we would need more than 30 days, Judge, to be honest with you, but I don't know what Mr. Davis is.
No, I think about 30 days would be great. Good.
Okay, then you all can come back on September the 15th at 9:30 for approval.
And Judge, if we get those, just so the court is, if we get that done as an agreed orders, I'll definitely work it out with Mr. Davis and get in our signature and all on that, and we can just really, it would just be more coming in and put it into the record.
Yes. If you happen to have everything done before the 15th and you just want to make a quick announcement and prove it up onto the record, just notify my staff and we'll try to squeeze you guys in somewhere. But it does have to be proved up by at least one person because there are children involved.
Yes, sir. And we'll take care of that, Judge. Like I said, I'll get with Mr. Davis this afternoon and try to see if we can come up with a date where we can all just sit down and get this thing worked out.
Okay. Anything else, gentlemen?
That's all I have.
That's all I have, Judge. Thank you.
Okay. Yes, y'all have a great day.
You too. Thank you, Judge.
Okay, Ms. Cantu del Bosque.
Good morning, Your Honor. I raised my hand, Your Honor, because I have to get back to 206, but I have a default prove up, Judge.
Okay, so do you want to jump into that court and then come back, or what do you want to do?
It's up to you. I jumped into this court. I've been waiting over there since 8:30, Judge, but I can finish up over there and then come back if you'd like.
Okay, well, we'll still have some cases. While I have you on, are you all still on for this afternoon?
As far as I know, Judge, we are. However, I will ask that we confer before.
Okay. All right, I'll wait for you to jump back on.
Thank you, Judge.
Okay. Ms. Diaz, I'm sorry, ma'am. Did you have a quick announcement? I didn't see a reaction, but no.
No, I do not, Judge. It's a hearing with Ms. Darlene Bell.
Okay. So then I saw Ms. Vale on too, and she didn't have a reaction button, so I didn't know if you all, okay. Then I'll take you up after Mr.
Our reaction is we're here to fight, Judge.
Oh.
There ought to be something like that, maybe a
okay. All
or
right.
something that we can give you.
Okay, then I'll get back with you just momentarily. Attorney Rudy Moreno.
Thank you, Your Honor.
Good morning, Your Honor.
Good morning, sir.
It's number, I believe, 45 on your civil docket. It is Mr. Gozmez Escobedo, Your Honor. I'm just standing in for Mrs. Audra Palacios Cruz on this.
Okay, that's F3397-21-9 in the matter of the marriage of Kimberly Escobedo and Cosme Escobedo. And is Mr. Jimenez coming on today?
I'm not sure, Judge. They have an agreement. This is just an announcement. They're going to meet. They're going to go into mediation and try to work out some issues that are involved in this matter.
Okay, and when are they mediating?
You know, I think that's just the date that him and Audra haven't come to yet.
Okay, and do you know if they've agreed to a mediator?
Not sure, Judge. Not sure, Your Honor.
Okay, I believe the last time that we were here, I had told them that if they were going to go to mediation, I would submit an order of referral.
Okay.
So I'll be doing that, okay?
Sounds good, Judge.
I'll set a deadline on that. Just remind them that any extension of the injunction, well, now it's an injunction. They need to have all of that in writing. I believe Mr. Escobedo is trying to raise his hand, but I don't know, Mr. Moreno, if you want to give him.
No, Judge, he has nothing to say right now, Judge.
Okay.
Judge, I can mediate the issue you want me to, Judge. Really, we need to get done right away.
Sure, there's no conflict there at all.
Nothing at all, Judge.
Okay, just go ahead and let them know. We'll submit an order of referral and mediation, and I'm gonna set them for a status on September the 15th.
Thank you, Judge. Judge, you want us to submit the order or your office is going to do it?
We will submit the order of referral and mediation. They will need to submit an order of any kind of extension.
Perfect, Judge. Thank you. I appreciate it.
Okay?
That's all I have, Judge. May I be excused?
Yes, you may.
Judge.
Okay, thank you. Attorney Tony Gomez?
Morning, Your Honor.
Good morning, sir.
I got number 18 on the court's docket, F3235149.
Okay, in the interest of Gregory Alexander Rangel.
This is a case that I filed a motion to non-suit on this morning, Your Honor. I filed a motion and an order. The child subject of the suit has turned 18 and graduated from high school, so there is no need for any further court intervention.
Okay, then I'll have that forwarded to my queue then.
There you go. That is all I have, Your Honor. May I be excused?
Yes, sir.
Thank you very much.
Okay, Mr. Reyes?
Good morning, Judge. Rene Reyes, number 4, Judge.
Okay, and that is F3353-20-9 in the matter of the marriage of Cesar Gonzalez and Sonia de Leon.
Judge, I represent the petitioner, Cesar Gonzalez, should be logged in. And it involves no property and no children.
And Ms. De Leon signed a waiver of service, is that correct?
Yes, Judge, it was filed on July 9th. That was an issue last time.
Yes.
But we refiled she refiled a new waiver of service July 9th. And a notice was sent. There was another issue last time because it was returned.
Yes.
But it was sent out and it wasn't returned.
Okay, and so then at this time, you still haven't had any contact with Ms. De Leon?
No, ma'am.
Okay, and so let me just call out her name 3 times. Sonia de Leon. Sonia de Leon. Sonia de Leon. Okay, no one has responded by that name and the name being called out 3 times. Do you want to move forward with a default divorce?
Yes, Judge.
Okay, Mr. Gonzalez, please raise your right hand. Do you swear that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God, sir?
I swear.
Okay, and Mr. Reyes, you may proceed.
Mr. Gonzalez, please state your name.
Cesar Gonzalez.
Are you the petitioner in this case?
Yes.
Are you married to the respondent, Sonia Esmeralda de Leon?
Yes.
Immediately before filing this suit, did you live in Hidalgo County for at least 90 days?
Yes.
In Texas for at least 6 months?
Yes.
Judge, we're asking the court to take judicial notice on July 9th, 2021. A waiver of service was filed.
Okay, the court will take such judicial notice.
Mr. Gonzalez, has your marriage become insupportable because of discord or conflict of personalities that destroys the legitimate ends of your marital relationship?
Yes.
Is there any chance that you can save your marriage?
No.
Are there any children of this marriage?
No.
Are there any adopted children of this marriage?
No.
Are any children expected of this marriage?
No.
Did you accumulate any community property? Real
No.
estate? Okay. Are you asking this court to grant your divorce?
Yes.
Judge, we respectfully request that the court grant Mr. Gonzalez's divorce.
Okay, the court will take judicial notice of all documents in the court's file, specifically the waiver of service that was e-filed by Ms. De Leon on July 9th, 2021, and will also grant the divorce today. So you'll be submitting a divorce decree, Mr. Reyes, by when?
By end of the week, Judge, I can get it in.
Okay, and just have your client sign off on it since you haven't had any communication with Ms. De Leon. And I'm just gonna set a tickler for August the 27th.
Thank you, Judge.
Okay.
Thank you. Nothing
All
further.
right.
Thank you.
Thank you. Okay, Attorney Peter Knapp.
Thank you.
Yes, Judge. I'm here for two matters, matter number 33 and matter number 37.
Okay, CL 191451-I, TD Auto Finance versus Erica Martin et al. And what is your announcement, Counselor?
Yes, Judge, we're just ready to move forward with trial on this matter.
Okay, so have you all attempted to contact them to see if they want to settle it?
I believe we have not had a chance to, or had any communication with the defendant in this matter yet.
Okay, but they have been properly served, is that correct?
Yes, they have been.
And did they file an answer?
I am not aware of an answer being filed in this matter.
Okay, so then will you be proceeding with a default judgment?
Yes.
Okay. Just file your motion for default judgment with an order setting hearing and we'll get that set for you.
Thank you, Your Honor.
Okay, how much time do you think you'll need to file that?
Probably just a few days, not long at all.
Okay, I'm gonna set a tickler for August the 27th. If it's not filed by then I'll reset you for another status.
Thank you, Judge.
Okay, and you said number 37?
37.
Okay, that is CL 196835-I, Bank of America versus Richard Leon. And what is your announcement, Counselor?
Same as before. We're ready to move forward with that matter.
Okay, and when was were the defendants properly served?
Yes, he was.
Was an answer filed?
Not to my knowledge.
Okay, then it'll be the same, just file a motion for default judgment with an order setting hearing attached. I'll set a tickler for August the 27th.
Thank you, Judge.
Okay, anything else?
That was all I had. May I be excused?
You certainly may, sir.
Thank you, Judge.
Okay, thank you. Attorney Vanessa Flores?
Good morning, Judge. I just wanted to let the court know Mr. Ramos is on. I know that it's not a quick announcement per se, but I did want to inform the court that we have mediated it. And there's just one particular issue that is up, I guess, for the court to make a decision on. I just wanted to inform the court before perhaps the court took on any long fights.
Okay, so there's just one issue, and then let me find out who everybody else is. And then we'll go ahead and see, because Ms. Vale and Ms. Diaz also have a contested issue, but I don't know if theirs is one issue or issues.
They also have one issue.
Okay, so we'll go ahead and I'll recall you as well. Just
okay,
give me a
thank you.
moment. Okay, Attorney Juan Guerra? Attorney Juan Guerra? Okay, Attorney Ricardo Benavides?
Did you call my name, Judge? I'm sorry.
I did, sir. I did, sir.
Good morning, Judge. I had about four different cases going on at the same time.
Okay, no problem. What number, sir?
I'm on cause number Rodriguez.
It's number 23, Your Honor.
It's an okay. I'm sorry.
Okay, that's CL 12-1705-I, Francisco Rodriguez et al. Versus North American Mortgage Company.
Yes, ma'am. This is a case, Your Honor, just very briefly. It's one of the oldest cases you probably have in the book since 2012. And it is weird because nobody's claiming he knows he owes about 30,000 and nobody has come forward to say you're behind payments. So we're trying to find out who owns the property, who is the last person that is holding the paper. And so you gave me more time to check on that. The lawyers that I've been talking to saying, no, we don't own the paper anymore. So I told my client that the best thing I could do is to go ahead and for them to go to like a Tierra Title, some of these title companies, and ask for a title search. And that'll give us exactly who owns the paper. Because it's weird. Somebody should be claiming that since 2012, nobody's making payments. He hasn't received anything.
Right. And I remember the last time you were here, that was my suggestion, was for him to get a title search on it done.
Yes, and
have they done that?
No, Your Honor, for some reason, I didn't follow through that. I just kept talking to lawyers and thinking that I could resolve it that way. I should have just listened to words of wisdom from the court and follow that, Your Honor, and ask them to do a title search.
Okay, let me see. Let me ask for some assistance if anybody that's an attorney knows. How long are those title searches taking these days? Anybody know, Mr. Ramos?
The last ones that I've done is between 2 to 3 weeks, Your Honor.
Okay, so let's just say that he does get on the ball and gets that title search done immediately. It should take about 30 days. So I mean, because I know it's been the same announcement since we began. So I'm gonna go ahead and give you till September the 29th. So he needs to get that title search done. And that way I know what direction we're going to take. September 29th at 9:30.
Thank you, Your Honor.
Okay, thank you, sir. Did you have anything else, Mr. Guevara?
No, ma'am, I think that's all I have. May I be excused?
You certainly may.
Stay safe, Judge.
Thank you, likewise. Okay, Ms. Sanguma, you have a pro se divorce? Okay, you're on mute now.
I'm sorry. Can you hear me now?
Certainly can. Is Mr. Rene Tanguma going to be joining us today?
I do not know.
Okay, so then I'm gonna call F3377-20-9. Okay, and you were to file a corrected waiver. Did Mr. Tanguma sign that corrected waiver?
Yes, Your Honor.
Okay. Hold on. Somebody's making noise somewhere. Okay, Miss Rivera or Miss Castaneda, can you please let me know when that corrected waiver was e-filed, please?
Judge, I don't believe that it's been e-filed. I believe, well, first of all, the feedback is coming back from Ms. Tanguma.
Okay, Ms. Tanguma, there's something wrong with your audio, so I'm gonna mute you. Okay. Okay.
Okay, Judge, the final decree was filed and it was signed by the respondent, Mr. Tanguma, but the waiver was not filed.
Okay, are there children involved?
It reads no children, Your Honor.
Okay, Miss Tanguma, try to mute. Miss Tanguma, do you all have children?
No.
Okay. So they filed a divorce decree that has both their signatures on it. Okay. I'm gonna ask you to log out, Ms. Tanguma, and log back in because something is giving you really bad feedback.
Okay, let me do that.
Okay, Mr. Benavides, I had called you a bit ago.
Yes, Your Honor. Good morning.
Okay, you were probably on another hearing. Which number are you on the court's docket?
We're number 10 on the court's docket.
Okay, CL 20-0071-I, Julia Esparza versus Walmart Stores.
Your Honor, Ricardo Benavides for the defendant, Walmart Stores, Texas, LLC. The plaintiff, Julia Esparza, is pro se. We've got a motion for summary judgment before the court today. We did provide Ms. Esparza with notice of today's hearing. We did so both by first-class mail as well as certified mail return receipt requested. I've got the green card that shows she signed for it on July 12th. What is that, 12th or 17th? It's either the 12th or the 17th, Your Honor.
Okay. Okay, let me call out her name 3 times. Julia Esparza? Julia Esparza? Julia Esparza? Okay, I don't have anyone by that name. You want to proceed?
Yes, Your Honor, if I may.
Go ahead.
Thank you, Your Honor. This is a relatively straightforward motion for summary judgment. Ms. Esparza originally filed a premises liability claim against Walmart in connection with a January 12, 2018 slip and fall incident that occurred at the gas pumps of Murphy, USA. The petition was filed pretty close to the statute of limitations. And in the course of discovery, it was determined that the fueling station or the gas pumps were not owned by Walmart on the date of incident, but they were actually owned by Murphy USA. Murphy USA, it was, I guess from the plaintiff's perspective, it was too late to bring Murphy USA in because the statute of limitations had expired. But basically our motion for summary judgment is predicated on the fact that, or the assertion that we did not owe her a duty of care on the date of incident because Walmart did not own the premises on which the incident occurred. Attached to the motion for summary judgment, we've got the Hidalgo CAD report that indicates that beginning in 2018, Murphy Oil USA was the owner of that property. Additionally, there is a special warranty deed from Walmart to Murphy dated April 21st of 2008, whereby the property in question was conveyed from Walmart to Murphy Oil USA. So because Walmart didn't own the property, it did not owe her a duty of care. And for that reason, motion for summary judgment is appropriate.
Okay, then the court will take judicial notice of all the documents in the court's file, specifically that Mrs. Barca, the plaintiff, was served with notice of today's hearing and the motion for summary judgment, and she failed to file a response and failed to appear today. The relief requested by the defendant is hereby granted. Mr. Benavides, do you have an order on file?
I believe an order was filed along with the motion. What I can do, just out of an abundance of caution, Your Honor, is go ahead and submit a proposed order, whether it's duplicative or not.
Okay, then I'll wait for the most recent one to be filed and I'll ask for that one to be sent to my queue.
Very good, Your Honor. I'll have that done today.
Okay.
I have nothing further before the court. May I be excused?
You certainly may, sir. Thank you.
Thank you, Your Honor. Be safe and have a good day.
Likewise. Take care.
Thank you.
Okay, Ms. Sanguma, let's try it again.
Okay, can you hear me now?
Yes, very good.
Okay. Oh, sorry about that.
That's okay. Okay, so Ms. Sanguma, I'm gonna recall F3377-20-9. So
Yes.
Mr. Tanguma, although he did not e-file the corrected waiver, he did sign the divorce decree, which
Yes.
acknowledges that obviously he knows about the divorce and the terms of the decree he has also agreed to. So I'm going to go ahead and accept that divorce decree. And I'm going to ask you to raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God now?
Yes.
Okay, please state your full and legal name for the record.
Jennifer Tanguma?
Okay, ma'am, and you are currently married to Rene Tanguma, is that correct?
Yes.
Okay, and Ms. Tanguma, at the time that you filed for divorce, were you a domiciliary of Texas for at least 6 months and a resident of Hidalgo County for at least 90 days, ma'am?
Yes.
Okay, and ma'am, are you currently expecting a child of this marriage?
No.
And ma'am, did you file a divorce because your marriage has become insupportable because of discord or conflict between the personalities of yourself and of your husband? In other words, you two are not getting along.
Yes.
Are you asking the court for a divorce today?
Yes, Your Honor.
Okay. And ma'am, do you and your husband have any children together?
No.
And do you and your husband have any community property together?
No,
And did your husband sign the divorce decree that you have e-filed with this court?
yes,
Okay, and over the years, you've become familiar with your husband's signature, is that correct?
yes,
And is that his signature on that divorce decree?
yes, Your Honor.
Okay, ma'am, and on what date did you get married?
On June 27th, 2005.
And on what date do you recall being separated and no longer living as husband and wife?
About a year and a half later. So
Okay.
we've been separated like 14 years, actually.
Okay, so do you remember what you put on your petition for divorce?
Yes, I put 2007. I had the date wrong.
Okay.
When we got married, I had it wrong, and I had to go and look it up. I was like, I can't remember when I got married because it was so long ago.
I understand. Okay, so for your separation, you have October 1st, 2009. Is that date more or less correct?
Yes. Well, no, because it should have been 2005 to 2007, which was
Okay.
almost a 2-year.
So then it would be on October 1st, 2007.
Yes, Your Honor.
Okay, okay. Now, you stated that you have some separate property?
No, we don't own any property together or anything.
And how about your, oh, I think you mistakenly put a paragraph for separate property. So you do not have any property that you own separately that you wanted confirmed today?
No.
Okay. And ma'am, you are asking for a name change to Jennifer Ramos?
Yes.
Okay. And that'll be granted?
Thank you, Your
So,
Honor.
since you have no community property to be divided, then each of you will stay with your own personal effects that you have in your possession. Okay?
Yes.
Okay, then the court will grant your divorce today and the relief that you have requested and is set forth in further detail in the final divorce decree that has been e-filed with this court and bearing both you and your husband's signature. Okay? So
Okay.
I will ask for that decree to be forwarded to me.
Okay.
All right. Okay, ma'am. Well, as soon as I sign off on it, then it should be sent to you and you can decide what to do as far as changing your social security and changing your driver's license.
Okay. Thank you, Your Honor.
Okay, best of luck to you, ma'am.
Thank you, ma'am. You have a good day.
Likewise. Thank you, Ms. Ramos.
Bye-bye.
Okay. All right, so we have a David Trevino.
Yes, ma'am. Good morning.
Okay, good morning, sir. What case are you here on?
So I am number 15 on the docket.
Okay. And that's for an adult name change?
Yes, ma'am.
Okay, sir. And do you have everything on file?
Yes, ma'am.
Okay, I'm gonna double check because most of the time they don't get the fingerprints back to me.
Got it. Okay.
Do you recall doing your fingerprints?
Yes, ma'am.
Okay, and did you send that to the state?
Yes, ma'am. I do have a second set if need be.
No, I have it here. You actually did it correct.
Okay, perfect.
Okay, Mr. Trevino, will you please raise your right hand?
Yes, ma'am.
Sir, do you swear that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay, so your current name is David Trevino, is that correct?
Correct.
And you're asking the court to change your name to David Slovak, and that's Slovak, is that correct?
Yes, ma'am.
And sir, can you please tell the court why it is that you want to change your name?
So the process has been going on for about 15 years. We, I guess, finally got everything together to put the name change through. It's my father's last name. It was, I guess, some random happenings while I was a child, but everything's been clear, so we're all on good terms now.
Okay, so what is Slovak?
Slovak is my father's last name.
Your father's last name.
Yes,
So
ma'am.
Trevino is your mother's last name.
Correct. It was her maiden name.
Okay,
Is
so
there-
now you want to carry your father's last name.
Yes, ma'am.
Okay. And how old are you, sir?
I am 36.
Okay. And sir, changing your last name, you are not asking for this so that you can avoid any criminal charges and any pending matter against you.
Correct, ma'am. Nothing pending. Mhm.
And so as a matter of fact, you filed your criminal history report
Yes, ma'am.
with the court on July 9th, 2021. Is that correct?
Yes, ma'am.
Okay. And you're a realtor?
Yes, ma'am. And a teacher as well.
Okay, so you have no prior criminal history, is that correct?
Correct.
Okay. Okay. So you will need to submit a proposed order. So I'm going to take judicial notice of all the documents in the court's file, specifically your original petition that you filed and also the criminal history report that was filed with the court on July 9th, 2021. I'm going to make a finding that you are wanting your last name changed so that you can bear your father's last name and that you are not doing it as a result to avoid any criminal charges that may be pending against you, okay?
Correct.
I'm gonna
Yes.
further make a finding that the criminal history report finds that you do not have any prior history of arrest or any type of criminal history. So Mr. Trevino, from this day forward, you will be known as Mr. Slovak, and you do need to file an order granting that, sir. And you can't change anything until you file that order with me, okay?
Okay.
So as soon as you file it, I'll have that forwarded to my queue and make sure you include an email where you can also receive the order as well.
Okay.
Judge, if I-
Okay? Yes.
Mr. Trevino has in fact filed that order.
Oh, he has already filed the order?
Yes, it just, for whatever reason, I can see where you could, it looks like it's skipped, but it's there. Yes, ma'am.
Okay, well then I'll go ahead and have that forwarded to my queue and Mr. Slovak, and then we'll get it taken care of for you so you can get all your licenses changed.
Perfect. Thank you, ma'am.
Okay. All right, congratulations, sir.
Thank you.
Okay, take care. Have a good one.
You too. Thank you, ma'am.
Okay. So, Juliana Barco.
Yes, ma'am.
Okay, which case are you here on, ma'am?
I'm waiting for Miss Cynthia del Bosque.
Okay, she's going to be with us shortly. She's in another hearing now.
Okay, thank you.
Okay, thank you. Okay, and I have Alyssa. Alyssa, is that any one of y'all's?
Yes, that's me.
Yes, Your Honor, that's my client, Alyssa
Oh, okay,
Hilario.
that's then, okay. And who is on the AE 23? AE 23? And, okay, the LG Stylo 4 never could connect. Okay, so let me go ahead. So both Ms. Diaz, you and Ms. Bale also only have one issue?
Yes, Judge, well, it's for the pickup and delivery, Judge, and also the designation of the competent adult.
Okay. And Ms. Flores and Mr. Ramos, what's your one issue?
Your Honor, we were able to mediate every issue except as far as who can be present during the visits. And it has to do with my client's girlfriend who lives in his home.
Okay, that's common. That's a common problem that most family cases will have as well.
Yes,
Okay, well then let me go ahead and just take you all, we'll be ready to move forward. So Ms. Diaz, what number are you all on the court's docket?
Number 19, Your Honor.
Okay, then I'm going to call F 3426-13-9 in the matter of the marriage of Luis Alberto Garcia and Laura Leticia Garcia.
Good morning, Your Honor. Melinda Diaz. I'm here for Miss Laura Calderon.
Froze up, can't hear. Hello?
Okay. Ms. Vale, can you hear us?
Now I can hear you. I did not hear anything Miss Diaz said.
Okay, Ms. Diaz was just making an announcement as to who she represents.
Okay, Your Honor, I am here.
Judge, I believe it's my motion.
Okay,
I'm
but
sorry?
so Ms. Vale represents Mr. Luis Garcia?
Luis Alberto Garcia, that is correct, Your Honor.
Okay, so then, Ms. Diaz, you have filed the motion to set surrender, return, and designation of competent adult.
That is correct, Judge. Judge, for the court's information, this case was mediated on July the 14th. Any of the other issues that we had pending have been resolved, such as the primary residence, the visitation schedule, child support, and things of that nature, Your Honor. What we have not been able to reach an agreement, Your Honor, was that the designation of a competent adult, in addition to, Judge, the location for the return and the surrender and the return of the children. For the court's information, Your Honor, in this case, there are two 16-year-old twins, female twins. My client has been named as the primary, the person to establish the primary residence, and Mr. Garcia is to have his standard visitation. In this particular case, Your Honor, Mr. Garcia, I'm not sure as to the legal status, but is involved in a relationship with a Mitzi Morin. Mitzi Morin has a protective order against my client, Laura Calderon. There has been so many issues, Judge, based the mere fact that there's a protective order should give notice to the court that there's issues. In addition
Are we
to
going to do testimony? I'm going to object, Your Honor. I don't have a problem with getting an issue, but I have a problem with Ms. Diaz testifying. Either she takes the oath and I get to cross-examine her, or she doesn't get to tender in what she believes is the evidence, Your Honor. She has to present it.
Judge, and I don't have a problem. I'm giving a synopsis to the court, and there's a protective order. I don't think you need to have any type of evidence that there's a protective order that's been issued. That is a fact, Judge, and I believe Ms. Vale cannot dispute that there is a protective order between these two persons, and that's the whole gist of this reason of why we're having a problem with a competent adult, Your Honor. But I do have my client, and we're ready to testify.
So the thing is like, okay, so then the designation of a competent adult, according to the family code, is anyone over the age of 18. And it's a responsible adult. And I mean, so to get past that presumption, there has to be an issue. You know, like I used to explain to my clients prior to me taking the bench, I would always tell them, look, you can designate anyone as long as they're not a sex offender or somebody that's going to be hurting your child. So I'm asking, okay, so Ms. Diaz, let's just get to the nuts and bolts of it. Who are you, since that is a general, I guess a general statute, are you objecting, who are you objecting to being the designated competent adult?
Mitzi Morin, which is the person that there is a protective order that she has against my client, which is the mother of the children, which is the designated as the primary owner.
Okay, so then you're having an issue with Mitzi Morin, and then Mr. Garcia wants Mitzi Morin to be able to pick up the children?
That's correct, Judge.
Okay,
Your
so
Honor,
now
if I may be allowed to speak, Your Honor.
Okay, and I was just going to ask Ms. Vale, so can you clarify for me?
Your Honor, Mitzi Morin is my client's girlfriend.
Okay.
Okay. They have a significant relationship, and she has picked up these children in the past. There is a protective order against Mrs. Diaz's client, not Mitzi Morin, and not against my client. Despite all of that, because these girls are 16 and they seem to have a will of their own, they decided to go live with mom. And my client, in fact, the visitation is if the girls want to come. It's not even that we're forcing them to come. Because of my client's job and because of the tenacious type of
I'm sorry, Ms. Bale, I thought we were going to just
if I may,
Hold on.
Your Honor, but I'm allowed to object.
Yes, hold on. Let me hear what Ms. Vale has to say, and then if we need to do testimony, then we'll move forward with the testimony. So
my client has two other relatives that can sometimes do it, Your Honor, but because they also do not seem to get along with Ms. Diaz's client, they're not reliable. Let's put it that way.
So then the bottom line is that there's not someone that y'all can agree with that'll be
that is true. And then, Your Honor, there's the issue is we don't have a problem doing at a public place as opposed to the house, but I need to clarify on the protective order. The protective order has an exception that she has to stay 25 feet away from my client, because when they went for this protective order, and this protective order is in the 430th, and I can certainly have my staff file a copy for the court to review if the court wishes it, Your Honor. But it's pretty much except for that exception. Your Honor, if we end up doing a public place, whether it be the Weslaco police station trade-off or let's say the Chick-fil-A type of a deal, I think the girls, since they're 16, can wait inside. And I mean, mom, if it has to be mom, whoever she designates a drop-off person, certainly I don't see why they even have to meet with each other. We're not talking 5 years olds. We're not talking 2 years old where they got to go hand them to each other. We're talking 2 16-year-olds, Your Honor. I don't see why, if it should happen to be Mitzi that has to pick up the kids because he can't find anybody else because of his job, that they even have to meet with each other.
Okay, so hold on. On the visitation, Ms. Diaz said that it was standard, and Ms. Vale stated that it was only if the girls wanted to go. Is it both?
Correct.
Yes.
Yes.
Okay. So then,
in other words, they said we're going to do standard visitation, but we agreed that if only the girls want to go.
okay. So then how much time or how many hours prior to the visitation do the children have to notify dad that they are exercising the visit? Have you all?
They don't, Judge.
So they can call dad at 5:30 and say, I'm going, and he has to drop everything to do it?
Well, it's presumed, I assume that they would announce we're not going.
Okay, well, that was gonna be my next question, or, because the way that they can go if they want, to me, it's the opposite. I would assume they're never gonna go unless they're going to say they wanna go.
Correct.
Judge, there's a little bit more than, first of all, Judge, the only person we disagree with is Ms. Morin. We don't disagree with any of his other family members or anything.
I apologize, Ms. Diaz, but I can barely, for some reason, you're coming in very muffled. I can barely hear you.
Let me get closer. Is that better, Darlene?
Hold on, it might be your connection, Ms. Vale, because I mean, I can hear her, but go ahead, Ms. Diaz.
Okay, I said,
Darlene, what I had stated was that we didn't object to anyone other than Mitzi Morin. Any other family member, whoever he would designate, would not be a problem, Judge. But in addition to Judge, and I know Ms. Bell doesn't want me to go into any testimony, but I know my client's already available. There's been other issues, Judge, than other just because there's a protective order. That's just one of the standing reasons, Judge. There's been issues such as the children don't want to be picked up by this particular person because there was a physical confrontation between Mitzi Morin and their biological adult brother, because that's why he's not a party to this case. There was a physical confrontation with Miss Morin. That's why they have such a hard time going over to Dad's house, because of this physical confrontation.
Okay, hold on. And what does Dad do that Dad cannot pick up the child?
Your Honor, he works in the medical profession. I believe he's,
So is he on shift work that he may not
Yes,
be out in time?
yes. Mhm.
Okay, Ms. Diaz is shaking her head no.
That wasn't my understanding, but I believe that my client would be better able to tell the court exactly what his position is.
Well,
I'm here on the line.
I'm
Oh, there he
not, hold on, I'm
I'm
gonna
here,
ask
I'm-
Mr. Garcia, because he's on. So, Mr.
I'm here, ma'am.
Garcia, what is your title? What do you do for a living?
Your Honor, I'm a local truck driver. I come in the morning, whether it's at 8 in the morning, get out sometimes 5:30 to 7:30. The medical field is Laura Calderon, but I'm a
Okay.
local truck driver.
Okay, sir, so then you do get out past the time of what a pickup time would be?
Yes, it would be, ma'am. It would be passed that way. And I'm just to clarify something. In the past, I've had no problems with my current girlfriend picking up my kids. They've always gone with her. As a matter of fact, we just came back from a trip to Vegas. We were all together. So I don't see what the problem is or why that's being brought upon. That's what I'm saying. If it's a problem with my ex-wife meeting with her, which they don't have to, we could do the switch at the.
Hold on. You said ex-wife. Are we here for a post-divorce?
Yes, Judge. This is a modification, Judge.
Okay, because I hate it when they style it inappropriately. or
I know, Judge.
incorrectly in the thing. Okay,
Oh,
so
I'm
then,
sorry.
no, not you. Just it's
Okay.
it's just the way it comes out on the docket. Okay, so then, Miss Diaz, were you aware that Mr. Garcia had taken a trip with his girlfriend and his children out of town altogether?
Recently, no, Judge. I was not aware of that.
Okay.
It's not recent.
Ms.
Okay,
Calderon, when was it?
It was before April, I believe, and the girls have not been or seen their father or the ex-girlfriend since that trip.
Okay.
So since April, they haven't seen him or her.
Well, Mr. Garcia, when you say recent, I'm gonna think in the last few weeks. I'm not gonna think
No,
in the
no,
last
no.
4 months.
I meant recent because I haven't been after that, she never let them come back to see me. So, and there's been no communication with them at all till barely about a week or so ago. Which,
Okay. Because that's okay. Look.
Judge, I'm not sure if that was before or after the confrontation.
Okay.
Their Vegas trip.
So it's look, this is your motion, Ms. Diaz. If you're gonna want to put on some testimony, that's fine, you can. Do you, I'll give Ms. Vale an opportunity to also cross-examine them and any of your witnesses as well. Now,
Yes, Judge.
I'm gonna tell you all though, okay, so I'm not gonna do this long drawn out hearing. We're gonna tailor it just to why you are objecting to the pickup and drop off to be her, but I'm gonna have you all come back at 1:30 to do that, okay? And you're gonna have less than 30 minutes because I have a very heavy contested hearing at 2 o'clock.
Yes, Judge.
So I'm also gonna give you an opportunity to discuss this between now and then. Because look, I understand that it is convenient for Mr. Garcia to have his girlfriend pick up his daughters if and when this visitation happens. You all may be arguing about this visitation that may never even occur, okay? But it's fine. You have to have a backup plan because I'm sure Mr. Garcia is hopeful that he's going to have a relationship with his children. However, I am going to say, if there is this much contention between the parties, and if there is already a legal document such as a protective order against Ms. Calderon, and it's my understanding from the research, Ms. Calderon from Ms. Morin, and from my research, there's also a violation of that protective order pending out of County Court 8. So it just seems like these problems are building up. And why you would want those problems surrounding in the environment of your 16-year-old is beyond me. Instead of having female roles in their lives fighting, they need female roles in their lives providing a good role model and a positive relationship. But life happens. Personally, I'm just going to tell you that I do not think that anyone that has a protective order should be injecting themselves into picking up the children unless there's some boundaries like Miss Vale had suggested, which is they are of age. There can also always be dropped off by mom or by whomever or whoever her designation is, and they can wait while mom supervises them from the parking lot. And for Miss Morin to pick them up and not even get near mom's car. And the children are 16, they can walk out to the car. There's no discussion between them. They don't even get near each other. They don't violate the protective order. However, I can understand where the concern comes in if there is a protective order in place and you even place them in the same place. Because if you place these two individuals in the same place with a protective order in place, you will almost always have a he said, she said situation where you're going to endanger one person or the other. In this case, it will most likely be Miss Calderon because she already had a violation of her protective order pending. So that tells me that Miss Morin is very inclined in pressing any type of charges against Miss Calderon for any type of possible violation of that protective order. So why would we want to put anyone in that position? But if you insist in looking at this person, just so you know, you will have to come up with some parameters that you agree with. Number one. Number two, look for someone else. See if you can talk to anybody if this visitation even happens. Perhaps, Mr. Garcia, you may also think of if they're going to tell you that they're going to visit with you, is there any way, don't answer the question, something for food for thought, is there any way for you to make arrangements that on that date you will get out at 5:30? Just food for thought. Something so that you get out at before 6 o'clock and you're the one to pick up your children, not anybody else. Because if this visitation occurs, it will more than likely only be occurring twice a month. So if you think you can work something out with your employer, so where you get off of work at 5:30 on a Friday twice a month, then that's something that you can also think of. But I can't force you all to come into any kind of agreement. The only thing that I can do is give you an opportunity to present your sides in court, which I will do at 1:30 unless you come up with an agreement between now and then. So my staff will email you the link for the afternoon one, and that way you will come on at 1:30 and I will take up the contested hearing at 2.
Judge,
Your
may
Honor,
I?
if we may ask, Your Honor, perhaps you can put us in a breakout room right now, since we have everybody here right now.
Who do you want in the breakout room?
Ms. Vale and
alternately-
myself and my
Yes.
Miss, and Judge, just for food for thought, as the court said, Judge, I know my client was amenable that the pickup does not have to be at 6 o'clock, Judge. We were willing to do it at any time before 9 p.m.
Okay.
So that he
So
wouldn't
those are
have those
all-
problems.
Those are all things you guys need to discuss. And Miss Calderon and Mr. Garcia, I'm going to tell you this. I have worked prior to being on the bench as a family law attorney for almost 20 years. Both of your attorneys have dealt with me. Both of your attorneys know what kind of line of thinking I have. Both of your attorneys know that I am very amenable to thinking outside of the box. I am always for accommodating the children and the parties, but it also requires for your cooperation, and I mean both, not just one or the other, because I do not favor one or the other. It's both of your cooperation. Both of you really need to look at this as parents, not as we didn't work out or we both moved on and I need to blow you off. No, you're never going to blow each other off until even after your kiddos turn after 18. They have so many more life monumental moments that are going to come up. You're going to be dealing with each other. So you need to be very reasonable. Mr. Garcia, that's a good point. If you think, okay, I'm going to be out by 6, for sure, let's move the pickup time to 6:30. But, you know, if you really, really think there's no way that I could ever pick up these girls because I'm just stuck to this truck, well, then just tell your attorney, look, Miss Vale, there's no way, I can't. There's no wiggle room at all for me. So, you know, but I want to see the parties work together, because you should not come to the court to make your decision unless you're ready to accept whatever decision it is that I'm going to make, which means that you exhaust all remedies between the two of you all. So, you know, I'm gonna go ahead and assign Ms. Vale and Ms. Diaz into a breakout room for them to confer. If you need for me, you know what, come out if you need for me to do something else. In the meantime, I'll have your clients be on standby and I'll give you guys an opportunity to confer.
Okay.
So you can accept that invitation that's in front. Okay.
Thank you, Judge. Thank you, Your Honor. I'm accepting that.
Okay. Ms. Calderon, Mr. Garcia, please mute yourselves and be on standby. I'm going to recall the other case that I had before me.
Yes, ma'am.
Thank you. Okay, F1999, and I'll just say an extra 9 in precaution because I don't know if I said it, -21-9, in the interest of a minor child. Ms. Flores and Mr. Ramos, what do you have for me?
Yes, Your Honor, Vanessa Flores on behalf of Ezra Maldonado, who is the petitioner in this case. Mr.
Good morning, Your Honor. Juan Ramos here on behalf of Ms. Alyssa Hilario, the respondent and mother in this case.
So the dad is, your client, Ms. Flores, is with you, and Mr. Ramos, your client is on the screen. Is that correct?
That's
Yes,
correct.
Your Honor.
Okay, go ahead, Ms. Flores.
Your Honor, in this case, we did mediate with Ms. Evelia Signs on, I believe it was August 2nd, if I'm not mistaken. At that point, we were able to come to an agreement, and if the court wants me to, I can read what that agreement is. As far as possession and access, geographical restriction, primary, who's designated as a primary conservator, child support, retroactive child support, medical support, and then with the only issue being who's allowed to be at these visits.
Okay, and is this for temporary orders or
This is
for
for
final?
final orders, Your Honor. We have entered into this agreement. It's kind of a step, a phase in, as we had previously discussed, a phase in process. And then once the child reaches 2 years of age, then it goes to standard visitations.
Okay.
So as I said, we can either read that into the record. We have the mediated settlement or partial mediated settlement agreement that we've all signed off on. And that's just that commencing, this was this past week, August 6, 2021, that it would commence this, phase in possession and access.
Okay, and how long would the visitation period be where this person would be supervising?
So, Your Honor, in this case, we're now at supervised by someone other than biological mother in this case. So we're on to dad, Mr. Maldonado's own father, so the paternal grandfather in this case, is the supervisor now through the 91st day. So we're currently in that phase. Okay. Now, once we reach the 91st day, then it becomes unsupervised visits with my client. So all of that we're in agreement with. As a matter of fact, Mr. Ramos can correct me if I'm wrong, but we were very amenable and I think very reasonable with what we had agreed to as far as the phases were concerned, including medical support, child support, etc. The one issue that we had, and I believe that the one issue that Mr. Ramos's client wants to argue before the court is whether or not my client's significant other can be present during these visits. Now, to be completely honest with the court, and Mr. Ramos is aware of this also, my client's significant other lives in the home with him. She has, and this is something that they brought up in mediation, she has been or had been arrested prior to, this was before I think we ever came onto this case. That case is still pending out of Cameron County. It is a felony case, but it is, I guess, I don't want to make it sound like it's not a serious case, but it is a case where there was a possession of a vape pen, to which those results from that particular testing of the substance in that vape have not come through. So they charged it as a possession of a controlled substance, and it's a felony offense. Now, in that case, this particular person is on bond, has complied with bond conditions to remain drug-free, has a drug patch, etc. There are multiple people in the vehicle, without getting into too many details, but that case is still pending. There is no other charge. She's never been arrested prior to that, never had any other issues. And as I said, there's been no conviction, and we're currently in the process of handling that case out of Cameron County. Other than that, Judge, this particular individual has been present at the visits, has had contact with the child in this case. There have been no issues. As I said, this case that she's got pending is not injury to a child. There's not any children involved. So that was our main, I guess, main and only disagreement was whether or not this person could be present, given that one of the restrictions that Mr. Ramos's client wanted was that these visits take place in his home or in dad's home, etc. But she lives, there at the home. And so we agreed to supervised visits. We agreed to pretty much everything and anything, just to be able to form or at least get that relationship going with dad and child. And so at this point, I believe that Mr. Ramos's client at the end of mediation wanted there to be a restriction for the next 5 years for my client to not have any significant other present during these visits. Now, she did tell the mediator, and something that, I don't think Mr. Ramos would have an issue me saying, that this would be a mutual restriction. However, my client is having supervised visits. So yes, we have an eye on him. But again, he only has visits every first, third, and fifth weekends, to where, there's some supervision as to if this person is not present. But on the flip side, Judge, we don't have anybody that can monitor mom 24 hours a day, 7 days a week for the next 5 years to be able to confirm or make sure that there's no significant other in the presence of the child when she's not having access to her dad. And so that was the main disagreement, and the one issue that we couldn't come to an agreement on. All we're asking, Judge, is, as the visits have already occurred, again, we've even agreed to this particular person not being able to change the baby's diaper, and there's specific language in our mediated settlement agreement, but change the baby's diaper, hold, touch her, give her kisses, etc. And so at this point, we're just asking that particular issue not, be another restriction on the visitations with my client.
Okay, Mr. Ramos, any response?
Yes, Your Honor. So Ms. Flores was correct in that at some point in the mediation, there was a negotiation for a prolonged restriction. I know in talking with Ms. Eladio, her main concern is this initial period, this initial phase, and that Mr. Maldonado he be the one responsible to learn how to take care of their daughter and to do so. And Ms. Eladio does have some concerns about the presence of his girlfriend at those visits and maybe not helping that in the facilitation of that responsibility. Also, Ms. Eladio did express her concern that these issues that are ongoing with substance abuse are still relatively recent, that perhaps in this phase-in period, that any restriction of a third party in the visitation would allow for some sort of accountability to make sure that those issues aren't present. Of course, Ms. Eladio would be able to employ any sort of motion in the future to resolve any concerns if they present themselves again. For example, I did explain to her following motion modify, restraining order, and so forth, and also that the case would be before you again, and so you would have that familiarity with those issues because you remember all your cases. But primarily, Ms. Eladio's concern is focused in this immediate phase-in period, since we are just starting visitation, since Mr. Maldonado is learning how to be a dad. And so she's going through great lengths to give him ownership of that. She does believe, however, though, that the presence of this girlfriend, even though she does live there, is a hindrance and a safety concern at the end of the day, because there are ongoing checkups for doing substances and so forth. And to Ms. Flores's point about being able to see, what's going on behind closed doors, when those checkups or when that drug patch ceases to be employed in that criminal case, we're not really going to have any tool to figure out what's going on either. So, we from our position are just more concerned that during this phase-in approach that, third parties be excluded, that this be predominantly family, and that Mr. Maldonado take the initiative to raise his daughter.
Okay. So I think you made a statement, Mr. Ramos, that was very resounding with me, which is that pretty much you're saying that Mr. Maldonado needs to learn how to be a parent. This is a very small child that we're dealing with right now. But part of learning how to be a parent is also learning who should and should not be in your child's life. And a fundamental right that I feel all parents have is to make a decision what creates a safe space for their child. And although this young lady, who is his significant other, has found herself in this situation where she is facing these criminal charges are pending, which means that she is innocent until proven guilty. And I'm not going to make an assumption that she is using or is finding a way to use when she has a drug patch on her. I don't know how long she'll have that drug patch. And you are correct, Mr. Ramos. What will we do once that drug patch is removed? How are we going to keep tabs on her? But I have no jurisdiction over her actions. I have jurisdiction over Mr. Maldonado's actions. And one thing that mom may want to keep in mind is that if he chooses, he chooses to allow someone that is going to be a hindrance or is going to be a negative influence on your child, you all's both of your child, this is both your child, then shame on him, and you have every right to bring that up to me. You have every right to file a motion for relief requesting that visitation suspend immediately, in other words, immediately stop. You have every right to file a restraining order if you have evidence that he is allowing someone around your child and his child that is not safe. Your remedies don't stop because it's always going to be dependent of what the situation is. Right now, I'm sure it's a very scary time for both of you. It's always hard to let go, always. It's hard for you to let go, to allow your child to go over there for time with dad. And I'm sure it's hard for dad to let go and have you be with the child the majority of the time. Keep that in mind too, is that with you being with the child the majority of the time, you are the heaviest influencer on the child. You are the one that will have most of the time with the child to mold the child, to teach the child how to be a productive adult. When dad is with the child, he has to make every moment count. So if he chooses to pass off the child to other people, then it'll be shame on him. But look, in my experience, when someone agrees to things that are so restrictive and so hard for them to do on a daily basis, such as make sure that they don't touch the child, make sure that they don't kiss the child, make sure that person doesn't change the pamper of the child. that's going to tell me in all honesty that they're desperate to have any kind of time with the child, any kind. And so dad should know better than to bring anybody around that is a bad influence on the child. And that's a great, great burden for both of y'all to carry on you. All of us as parents, I can guarantee that we didn't file an application before God decided that he was going to bless us with carrying a child. I didn't fill one out. Ms. Flores didn't fill one out. You didn't fill one out. Nobody was checking to see if we were going to have our child's best interest in mind. That's just something that you have. That's just something that you know as an instinct, as a parent. You're instinctive, whether you're mom or whether you're dad, you're instinctively protective of your child. So that is going to be something that both of you are going to have to learn how to do as far as accepting other people. Because like I stated the last time, you guys are really, really young. And you're going to have so much more of your life to live. And who you choose to live your life with, you're going to have to make a decision as a parent first. Is this person a positive influence for my child? Is this person a positive influence for me? And the code doesn't really control, well, the code doesn't control at all who can be present at any of the visitations when either one of you have the child. Just doesn't. The bottom line is what's in the child's best interest. And the state legislature has chosen to trust parents to make that decision. And I'm not going to put in an order where it says that he cannot have his girlfriend around. And I'm not going to put in an order that says that you cannot have any future significant other around. And I'm not going to put in an order that is so restrictive that it binds you for 5 years. I'm just not. I'm also going to follow the lead of the state legislature and place a lot of trust on the two of you. Nobody's perfect. Nobody's a perfect parent. However, all of us as parents have a learning curve. We do. And you all are at the very beginning of that learning curve. Now, both of you need to keep in mind, who do you want your child surrounded by? And I'm hoping that both of you are strong enough and love your child enough to know when to cut out those negative people. Because any decision you make has to be with your child in mind first. No significant other is worth it. None. Because if not, I'm sure you will find yourself in front of me again. So, Mr. Maldonado, I'm going to trust that when the child is with you, that you will create a safe space for your child, and you will know who should be around your child and who shouldn't. And Mom, I'm going to also do the same with you, that you create a safe space for your child, and you know who should and should not be around your child. So I'm going to ask both of you to please raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, Ms. Flores. Oh, you're having a computer issue. Mr. Ramos, do you have the mediated settlement agreement in front of you?
Give me 1 second, Judge.
Okay, because she will not be able to prove it up.
Yes, she informed me right now.
Okay. Isn't that the beauty of technology?
It's a blessing and a curse. Okay, Your Honor, I can proceed.
Okay, you can go ahead and you can state the agreement onto the record, and then Both parties, I need for you to listen, and then I'm going to ask you if that's your understanding of the agreement.
Okay. Your Honor, we reached an agreement as to custody, and we have a phase-in plan that's going to start the following. And as far as custody, both parties agreed to joint managing conservatorship with mother as a primary conservator for home and school. As far as the possession and phase-in, commencing on August 6, 2021, Dad was to commence 60 days of possession as follows. Visitations were to be supervised by his father, Rick Maldonado. These visits were to take place at his mom's home under his supervision. The child's not to leave the parents' home during these visits, and the mom was to drop off the child at the beginning of each visitation period. If Miss Mia Maldonado was present, or I don't know Mr. Maldonado's girlfriend's last name, but if Miss Mia Maldonado was present, she was not to kiss the child, hold the child, or place the child's hands in her mouth. And as far as the visitation plan, this first period, it was to occur on the first, third, and fifth weekends of the month, on Fridays from 6:30 to 8:30 p.m., on Saturdays from 6:30 to 8:30 p.m., and on Sundays from 12 till 2. On the second and fourth weekends of the month, the visitations were to occur from 6 p.m. to 8 p.m. After this phase-in, after the 61st day, Mr. Maldonado was to have the same visitation. However, it was going to no longer be supervised. And then after the 91st day, an additional 30 days, the visitation was to continue, except the Saturday visitations were to be from 12 to 4 o'clock until the child turns the age of 2. When the child turns the age of 2, the dad was to have a standard possession order with first, third, and fifth weekends of the month, commencing on Fridays at 6 p.m. and ending on Sundays at 6 p.m. And then, of course, the Thursday visitations on the second and fourth weeks from 6 to 8 p.m. And then as per the agreement, both parties agreed to abide by Mother's Day weekend and Father's Day weekend visitation. The parent not in possession of the child on the child's birthday should have 2 hours with the child, and the dad shall have possession of the child on December 25th, 2021 from 8 a.m. to 6 p.m. Until all holiday provisions take place when the child turns 3. Once the child turns 3 years old, all standard holiday provisions come into effect. As far as child support, the parties agreed that child support was supposed to commence on August 10th, 2021, with Miss Hilario receiving $575 per month and every month thereafter. As far as retroactive, Mr. Maldonado agreed that to child support arrears in the amount of $4,025 for the months of January 2021 through July 2021, and this was to be paid at an additional $100 per month. As far as medical support, the child's currently on Medicaid, and the dad shall reimburse the state at $57 per month, and all non-covered medical expenses shall be 50-50 between the parties. And that's the total agreement that was filed with the court, I believe, as well, Judge.
Okay, I did mean to ask, so does Mr. Maldonado's significant other vape or continue to vape? Oh, you're on the phone, right?
Okay, Judge, I hope. Judge, I just needed to step away so that you don't get the really bad feedback, but
Yes.
she no longer does. And as I said, she has strict bond conditions out of that Cameron County case.
Okay, I just wanted to make sure. If not, I was going to put an order in place that no vaping or smoking happens around the child.
Judge, we don't have an issue with that being an order either, so it can be included in the order.
Okay, Mr. Ramos, we'll go ahead and do that. Okay, so Ms. Solera, you have heard, I'm sorry, Solario, you have heard the agreement as read into the record by Mr. Ramos, with the exception of what I have ruled on. Is that your understanding of the agreement, ma'am?
I'm sorry, did you say my name? Because
Yes, I did.
oh, okay, it's Ilario. I'm sorry. Yes, I did understand the agreement.
I'm sorry, how do you spell your last name?
Ilario. It's Hilario.
I kept hearing Solario. I apologize.
No, you're fine.
Okay, so Ms. Hilario, you heard the agreement other than what I made a ruling on, and that is your understanding of the agreement as put on the record.
Yes.
Okay, so Mr. Maldonado, I know that you cannot, there's a technical issue, but is that also your understanding of the agreement as Mr. Ramos put on the record? Okay, you've indicated yes with a thumbs up. Okay. So that'll be the order of the court, and the court will accept the agreement that was entered into the parties. That'll be set more in further detail in an order that is to be signed by the parties and the attorneys. And that, how much time, Mr. Ramos, do you think you all will need?
I think, Your Honor, we just need another 2 to 3 weeks to fine tune the order.
Okay, so what I'm gonna do, I'm gonna set a tickler for September 10th, just to make sure that it's been submitted. And I do
Judge,
want
and if I may just
go ahead.
Just really quickly, Judge, the other thing that I just wanted some clarification from the court. They, in mediation, we did agree to 6 to 8 on the Thursdays from the 2nd and 4th weeks. However, Mr. Maldonado sometimes I guess he gets out of work at 6 p.m. The mediator had explained that as long as there was any competent adult, and in this case it would be the supervisor for the visits, is present, then Ms. Hilario could drop off the child. And I know that this past one of the visitations not this past Thursday, but the Thursday before that, Ms. Hilario did call, I believe it was McAllen PD, even knowing that, obviously Mr. Maldonado wasn't going to be there right at 6, called, I guess, to inform them that she wasn't going to drop off the child or release the child to the supervisor, who was Enrique Maldonado in this case, until Ezra Maldonado was present. And so I'm just asking for some clarification from the court on that issue, because I know that that's going to continue to happen, just given the time that he gets out of work.
Okay, so the way that I used to advise my clients all the time in situations that were in yours, and which I'm going to state right now, is that as long as the party is going to show up for the visitation, and if you know that there's going to be at least a 30-minute window, you leave the child with the designated competent adult. So if the supervisor's there, then you leave the child with the supervisor, which in this case is the grandparent.
Okay, I just want to clarify real quick. It wasn't a Thursday. It was on Friday. The visit's at 6:30 because of work. So he gets out at 6. So we agreed to 6:30, and he was not there until 7. This was on a Friday.
Okay, but was the grandpa there?
Yes, but I wasn't made aware of that.
Okay.
So that's my fault. I apologize, but I just wanted to clarify it wasn't on a Thursday. On Thursday, he was there on time. It was on a Friday.
And you're gonna have these hiccups because you guys are barely starting on this order.
Yeah.
But
Yeah, and I do apologize.
okay, so yeah, it's fine to leave with the supervisor.
Okay.
Because, now if he was going to be gone the whole weekend, well, that's something else. You don't, then that he's forfeiting his time, because let me just make that clear too, Mr. Maldonado, that you do not ever give your time to anybody. If you're not able to do the visitation, then you just give up your visitation. But don't ever think that somebody else can do your visits for you. So. Okay, but that way you all have that clarified for the future, Ms. Flores. So you all will have until September 10th to submit your final order, okay?
Okay, thank you, Judge.
Okay, well, if nothing further, y'all may be excused.
Thank you.
Thank you, Your
Okay.
Honor.
Thank you. Okay, so Ms. Diaz and Ms. Vale, do you need me to recall your case?
Yes, please, Your Honor.
F 3426-13-9 in the interest of minor children. And what is the announcement, Counselor?
Your Honor, this case has reached an agreement in reference to the pending issues, which was the pickup and delivery and the competent adult. We have agreed that the competent adult to pick up and deliver the child from Mr. Garcia can be either of his 2 sisters or 3 brothers. We will specifically list their names. I do right now have Claudia Garcia, Mary Corpus, Javier Garcia. We don't have, and we'll include the other brothers and sisters' names on the list, Your Honor.
Yes, Your Honor, and I believe one sister-in-law, Araceli Mesa.
Mesa.
Okay.
Okay,
All
Your
right.
Honor, and the pickup and drop off will be at the Chick-fil-A in Westlaco, which is Westgate.
Okay.
But Your Honor, since we have all parties, can we already prove the modification up? And that way, all we have to do is submit an order instead of having to come back to prove it up, the modification? May we do
Yes.
that at this time?
Your Honor, if we may also, I think that we're gonna agree, even though we didn't have it, I believe that Ms. Diaz said she would agree to give my client 24 hours advance notice if they intend to do the visitation. That way we don't have to have the people waiting around or last minute cancellations.
I think if Darlene, that for it to be both ways, just also his intent that he will send someone to pick him up. After they give him notice that they're wanting to exercise, he'll respond with a notice that he will have someone to pick him up.
That's fine. That's not a problem,
Okay.
Judge.
Okay. Okay, let me have both parties raise their right hand. Mr. Garcia, can you please turn on your camera? Okay, do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Ms. Calderon, you're on mute. You're unmuted. You're good. Oh, she's not connected to audio for some reason.
Can you be louder, Laura? Judge, do you want me to, you see her, Judge, but I can have her on the phone for voice?
Well, why don't you read it into the record? And what we did with the other person was they just did a thumbs up.
Oh, okay.
That's all, that was the best that we could do, but she just disconnected.
I think, yes, Judge. I think maybe she's trying to reconnect.
Yeah, let me wait to see if she comes back on.
Are we the only ones left, Judge?
No, I still have one more.
Okay. Come on, Laura, where did you go?
It's a Monday, so.
Laura, we lost you. Okay.
You want to put her on speaker?
Laura, stay. We're going to put you on speaker. Hold on. Okay, Judge, can announce yourself, Laura.
My name is Laura Calderon, Your Honor.
Okay, so do you swear the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
Okay, so Ms. Diaz, will you be proving it up?
I can, Judge.
Okay, well, just.
They are the petitioners, but I don't mind.
Okay, well, however y'all want to do it, just put the agreement
Your Honor,
onto the
I
record.
think that we can just take that they signed a mediation agreement. The mediation is filed with the court that they're going to honor the mediation agreement. And if there's any disputes, I believe the mediation agreement requires that we discuss it with the mediator, Your Honor. So I think that is sufficient in terms of the prove up, and I think we can agree and stipulate they're both residents of Hidalgo County.
So, Mr. Garcia, can you hear me?
Yes, Your Honor.
Okay, so do you recall entering into a mediated settlement agreement?
Yes.
Okay, and those terms in that agreement, you understand, are irrevocable because you have executed that mediated settlement agreement?
Yes, I understand.
Okay, and are you asking me to accept that agreement?
Yes, Your Honor.
Okay, and Ms. Calderon, you also recall executing a mediated settlement agreement?
Yes, I do.
And do you understand that that mediated settlement agreement is irrevocable, ma'am?
Yes, I do.
Okay. And so are you asking me to accept that agreement?
Yes, Your Honor.
And are you further in agreement with what was stated by your attorney that we will be naming the Mr. Garcia's siblings and a sister-in-law as a designated competent adults available to pick up your children?
Yes.
Okay, then that'll be added to the order. So then the court will take judicial notice of all the documents in the court's file, will accept that there was a substantial change and that it was necessary to have a modification, that both parties have entered into a mediated settlement agreement, that the court is accepting that agreement, and it'll be set forth in more detail in an order to be submitted by what date?
Your Honor, if I may just to clarify on the record that the parties also agreed today to do the pickup at the Chick-fil-A in Weslaco, Texas, and that to give 24 hours advance notice of if the children intend to visit, and that my client will also advise them at that time that he will have somebody available to pick them up.
Yes, that will be added. That will be added to the order. Ms. Calderon, did you hear that?
Yes, I did.
Okay, and are you in agreement?
Yes, I am.
Mr. Garcia, did you hear your attorney? Mr. Garcia, did you hear Ms. Bale? He's frozen.
Yes.
Okay, and is that
Yes,
your,
I think,
and is that your agreement, sir?
yes, ma'am.
Okay. All right, Ms. Bale, then we'll, please make sure that that's in the order. How much time do y'all need?
I think about 2 weeks.
Okay, then I'm gonna do a tickler for September 10th, just to make sure that it's been submitted by that time.
Thank you, Your Honor. If we may be excused, we have nothing further. You want a submission date, September 10th, or is that?
Yeah, I'm just gonna set a tickler for September 10th to make sure that it's been submitted by that date. So you
Thank
all
you,
can
Honor.
do it however you want, okay?
Thank you, Your Honor.
Okay, well, I
If
commend
we may be
your clients for coming to an agreement.
Thank you, Your Honor.
Your Honor,
If we may be
please,
excused.
Okay, everyone's excused on this case.
Thank you.
Thank you.
Okay, F 1681-21-9 in the matter of the marriage of Juliana Barco versus Lucio Gonzalez. Ms. Cantu del Bosque.
Good morning, Your Honor. I believe it's Lucio Gonzalez.
Yes, sir. Yes, sir.
Okay, so Mr. Gonzalez, is he present?
Judge, I don't see him on the screen, and he was served by Petition, and we have not had a response or an answer.
I'm sorry, he was served by what?
By posting, Judge.
Okay, so when they're served by posting and there's no way to find him, is that correct?
Yes, Judge. Last that Ms. Barco knew, Mr. Gonzalez was incarcerated, and he was released from incarceration on or about October or November of 2017, and she has not had any contact with him since then and does not know where his whereabouts are, Judge.
Okay, then, but what I need for you to do then, please, is to file an order appointing an ad litem for the missing party.
Very well.
And that any fees would have to be paid by Ms. Barco.
Okay.
And then once that person comes on, they're going to just make sure that there was an effort, and you know how that goes, just to protect that party's interests, and then we can move forward with the divorce.
Very well, Judge.
Okay.
At that time, Judge, would you like for me to request another final hearing once that's done, or?
Just okay, what you'll do is go ahead and file your order appointing the ad litem for the absent party on the citation by posting, and you can file an order resetting final hearing after you receive who is the person that is appointed as the ad litem, so that it includes that person on your order resetting final hearing, if that makes sense.
Very well, Your Honor. And the court will appoint someone for that at
Yes.
item. Very well.
Yes. Okay,
I'll go ahead and do that. Thank you very much, Your Honor. Ms. Barco, you can go ahead and log off. I'll explain to you what's going on.
okay, and we'll see you this afternoon.
Thank you very much, Your Honor.
Okay, take care. Okay, who is Jason? Jason? Okay, unmute yourself, sir.
Yes, ma'am.
Okay, and what case are you here on, sir?
It's a rental. He breached his the landlord breached his contract. I believe my attorney's on the line as well.
I don't have any more attorneys on.
Really?
Who was your attorney?
Carlos.
Oh, sir, yes, that was taken care of early on. I was told you all settled it.
Oh yeah, we settled it. You just
Okay.
tell me to sign in.
Yeah, your attorney took care of it.
Okay, you have a blessed day, ma'am.
Thank you. You too, sir.
All right, bye-bye.
Take care. Okay, so let me go over what I have that's left on my docket. Okay, do we have anything for number 9? You're on mute.
Sorry, Judge. We don't have anything, nothing was filed passing the hearing, Judge.
Okay, CL 173697-I, Dennis Hendricks versus Richard Bella. This was set for a motion for default judgment. None of the parties appeared. Please set this on the drop docket.
Yes, ma'am.
Okay, then I have number 16.
Number 16, Your Honor, they filed a Rule 11 in an order resetting.
Okay. Number
We have nothing-
17.
Nothing was filed, Your Honor.
Motion for. So they filed a non-suit?
Well, they filed the non-suit, the motion, Judge, but they never filed the order.
They didn't file the motion on that. I mean, they didn't file the order for the non-suit?
That's correct, Judge. I can double check. Give me 1 second.
Ma'am, I do see an order, proposed order in June 30th.
Yes.
Okay, so just have that forwarded to my queue then. Number 20.
Number 20, Judge, there was an order resetting and a Rule 11, and it's reset to September the 15th.
Okay. 31.
31, Judge. Oh, there was nothing filed.
And the attorney was on.
Correct. But I believe, Judge, maybe that Mr. Quintanilla was representing Victor Barrera. Let me double check.
Oh, yeah, and he was non-suited.
And he was non-suited. Non-suit.
Okay, reset that for September 15th.
Yes, ma'am.
34.
Ma'am, 34, I see that they filed a non-suit on Friday.
Yes, ma'am.
On 34?
Yes, ma'am.
Did they file an order?
Yes, ma'am, they filed it Friday.
Okay, just have it forwarded. Okay, that takes care of the docket for today. That concludes our Monday, August 16, 2021 civil docket. We are off the record.